Good morning, everybody. Happy Tuesday. Welcome to TCF Live. My name is Dan Soul. It is good to have you with me. I'll be your guide for the next 4 hours through Courtlandia. I am pleased to start our day with Judge Middleton holding court in the historic circuit courtroom in St. Joseph County. This seems like a fitting place for him to finish off his career.
Tincher?
Yes.
Yes. The final number here is 26582OD. It's an ordinance case. And you got charged in Three Rivers with operating while intoxicated.
Yes, Your Honor.
Ms. Tincher, bear with us. We're working on everything. That's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Carries 6 points on your driving record, and it requires that your license be suspended. Can't tell very much about this other than it happened at about 11:40 on March 31st. At Wood Street at Michigan Avenue, not too far from your house. I would suggest, Ms. Tincher, that we get an attorney to help you with this and set it for a pretrial conference. Is that acceptable to you?
Yes, Your Honor.
I'm gonna have to get a taller chair in here. Sitting like this for
Yeah.
8 hours is gonna kill me.
Yeah. No, sorry.
Oh.
No.
We have crammed full the first Friday of May. So we're gonna go all the way to the first Friday of June. I'm gonna set an attorney pretrial for June 5th at 8:30. The air conditioner just came on and it has a noise. We haven't experienced that yet. Appoint an attorney. What do you do, Ms. Tincher?
What do I do?
Yes.
I'm a stay-at-home mother right now.
All right. Well, I'm going to send you out to the court office with the bailiff. He will take you out to the clerks. They'll give you some paperwork with your attorney's name and number on it. I want you to call that attorney, make an appointment to discuss this with them prior to June 5th. Okay, don't get in any more trouble till I see you
Your
then.
Honor. Thank you so much.
All right, well, just a minute. I'll make sure that you don't owe me any money. Don't think so. All right, you're good to go. Thank you.
Okay, thank you. Have a good day.
All right, we're working on it. We got to start somewhere. All right, Mr. Guthrie, would you come forward, please? Well, we are limited for space up here. Good morning, Mr. Truckee.
Sorry, sir, I'm going to tell you, I have a hard time hearing.
All right, I'll try to speak up. Can you hear me?
Yes, sir.
We do have some hearing assist headphones. Would you like those?
Yeah, sure.
All right. I gotta fix this chair. Or grow taller.
Oh, no, no worries at all. You put those on, just make sure you can hear it. It's not loud enough.
And Your Honor, the dynamics are a little tricky, that it is difficult for us to hear here. Can you say his name one more time, Your Honor? I didn't see the.
His name is Justin Albert Guthrie.
Got it. Okay, thank you.
Yeah, here you may, now there are some speakers here. We've been working on the sound. Judge Patterson's courtroom has terrible sound. Anyway, Mr. Guthrie, you got a lot going on here. You're charged with driving suspended, first offense and open intoxicants from an incident that occurred on October 28th of 2025. A warrant issued back in December, and you didn't get picked up until April, when you got arrested for domestic violence, second offense, and cruelty to animals. That case is 264 or 605 SM. Domestic violence second offense is the most serious charge. It's a misdemeanor punishable by up to a year in jail and a fine of up to $1,000. My suggestion, Mr. Guthrie, is we get a lawyer to help you with this. These cases could have serious consequences. Do you understand?
Yes, sir.
Is that agreeable to you?
Yes, sir.
Are you still living in Schoolcraft?
I live in Fairwood, but I've been staying in Schoolcraft.
All right, well, because of this, is there a no contact order? Let me look at this.
I didn't know I had a no contact order.
All right, let's take a look. The warrant says that you assaulted Rachel May Guthrie, your spouse, and at 301 East Street, and that you had a previous conviction for domestic assault, making it punishable by up to a year in jail and a fine of up to $1,000. Second count is you did cruelly drive, beat, or work an animal. That's a misdemeanor also, punishable by up to 93 days in jail or a fine of up to $1,000. Because of the no contact, are you staying at the Schoolcraft address?
Yes, sir, that's my mother's address.
All right. Are you still working at Walgreens?
No, sir,
Are you working anywhere?
not at the moment.
Your health problems have been catching up with you?
Yes, sir. My diabetes has got pretty bad.
Appoint an attorney, set attorney pretrial for 6/5/26 at 8:30. Keith, we're doing the same thing. We're overloading that day of the month, but
Yep.
it just is what it is. Mr. Guthrie, these are all potentially serious charges. The driving suspended charge is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. It could further suspend your license. You've had license issues for a while now. But the most serious charge is a second offense domestic assault. I don't know very many of the facts. All I know is what I told you from the complaint. So I'm going to do the same thing. I have the court officer take you out to our office. They're going to give you the paperwork with your lawyer's name and number on it. I want you to call that lawyer, make an appointment to discuss it with him prior to June 5th. That's a long way away. The next available date would be May 1st, which is 10 days from now, but that day's already overfilled. So you go with the court officer, your next court date is June 5th. All your bond conditions remain in effect.
Yes, sir.
Tiffany Mead, you go with the court officer. Take your headphones off.
Did you guys actually have a sign-in sheet? Did they actually have a sign-in sheet?
For the amendments.
Yeah.
To the judge.
Oh, you did? Okay. Because I'm like trying to judge the budget schedule. Okay. So I didn't have, I'm trying to backtrack and find everybody because I didn't have the sign-in sheet this morning because we didn't have our normal.
Do you need more info?
No, I think I'll be
Mr.
okay, but I
Guthrie
think
had
only 4
two
people
cases.
signed in. And
Yes, and
I'm
there's-
assuming you have more than that.
I
So
see others. I see Mr. Kelly and I see other people that are here. We'll see.
just try to forensically put it together here.
Well, we're working the bugs out to be sure. What's that? Yes. Oh, are you Rachel Guthrie? Oh, just a minute. Stay here for a minute. I don't see a bond form.
Just wanted to make sure that we're not doing anything wrong by neighboring.
Well, I don't see a no contact provision here. And I gave the file away, so I can't even tell what the bond was. $200 cash or surety. Did he get fingerprinted?
No, I teach.
What? We can't do fingerprints?
I teach.
Oh. Apparently there is not a no contact provision in there.
Okay,
All right, you're good to go.
okay, thank you, sir.
That, something's not quite right with that complaint. My sheet says Tiffany Mead. Is there a Jonathan Mead here? Yes.
Good morning once again, everybody. Welcome to TCF Live. It's Tuesday. It's nice to have you all here again. This is Judge Middleton in the historic courtroom. This is where he'll be finishing his career as they remodel the other part of the building. Good to have you all here. We're going to continue with Judge for a while. There is not much going on in Courtlandia yet, but we'll move around eventually.
Well, I don't think you're in my queue. So give me, not only do they call you Tiffany, I don't seem to see your case here. I'm not crazy. It's not here. Give me a minute. No, boy. I can't find it. Let me try it by case number. 6 dash. You got a ticket in Three Rivers on March 30th for driving without a valid license ever applied.
Yes,
It's
sir.
a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $500. According to driving record, your license is expired. You have a real ID. You don't have anything. You don't have a speeding ticket. You don't have any. The date of this ticket was April 30th.
Yes, sir.
And I don't know what date your license expired, but you have 0 points. Mr. Tim George, the Three Rivers City Attorney, is here. This is an odd one. Did you have a license at one time, or at least a temporary permit?
I had a temporary permit before.
And the temporary permit expired and you never got the actual license?
And then before I came here, I got it renewed again.
All right, so you have your license now?
No, I got the. a
Temporary
again.
permit?
Yeah, I was ready to go take the driver's test.
I see you had somebody bring you here today.
My father.
Very good. Mr. George, have any thought on this?
You know, based on that, Your Honor, we'd be willing to do the reduction to the 326.
All right.
M-E-A-D.
A-D,
Yes, sir.
first,
Johnson, J-O-H,
is it 8? Okay, it's not just that.
and A-T-H-A.
Got it, thank you.
Let me find one I got. I'm gonna get a flashlight. Mr. George is the city attorney for Three Rivers, at least one of them. And this is charged under Three Rivers City Ordinance. So he's agreed to amend this charge to a charge of allowing another to violate the motor vehicle code. That one doesn't carry any points, doesn't go on your driving record, won't affect your ability to get your license.
Thank
You
you.
understand?
Yes, sir.
If this charge hit your driving record, it would prohibit you from getting your license for about 180 days. This charge, it is a minor misdemeanor, but it won't go on your driving record. And if you pass your driver test, you'll be a lawful driver. Okay?
Yeah, Your Honor.
Are you willing to plead to that charge?
Yes, sir.
So where were you going on that day, March 30th?
I was on my way to Paul's Pantry within a block of my house.
You should have just walked.
Yes, Your Honor.
All right, whose car were you driving? All right, well, she can get in trouble for letting you drive a car, but that isn't gonna happen here. But you've done what we wanted you to do. You went and got it renewed, you got your temporary permit, you're gonna take your driver test. You're gonna be good. All right, the fine is, well, let me ask you a couple things. Anybody promise you anything to get you to plead to this? Did any, other than this plea offer? Anybody promise you anything other than they would reduce the charge to this other charge?
No, sir.
Anyone threaten
No, sir.
you? Did anyone give you a copy of an advice of rights this morning?
Yes, Your Honor.
You understand you're giving those rights up by entering this plea?
Yes, Your Honor.
Very good. All right, now, Mr. George is a man of faith and he believes you're gonna pass your driver test. So rather than make you come back here all over again, you're just gonna do this deal right now. So that's a good thing for you. Are you working somewhere?
Yes, Your Honor.
Why is that?
Where is that? Your
Yeah,
Honor? Kalamazoo, Michigan, trim packing.
all right, yeah, you need to get your license. All right, so well, the fine here is $100. There's a $75 crime victims' rights fee and a $50 state minimum fee. That $125 goes on everything because the state thinks that everybody is rich. That goes to help fund the court. Some other things. All right, can you pay that today or need time to pay it?
I should be able to pay that today, Your Honor.
All right. Well, you can go right out to the court office there and pay it. They'll give you some information. You can pay with credit card, green cash,
Yes, Your Honor.
or cryptocurrency. We don't take cryptocurrency. Anyway, you pass your driver test and you'll be good. This won't jam you up, but you do have to pay this $225 fine. Just like everything else, the cost has gone up. But you're good to go.
Thank you, Your Honor.
Sorry, we didn't have your file in there. Did you have that one, Tim?
I'm sorry.
Did you have that in your queue? That case?
What was the last name?
His name was
It was Mead.
Mead.
Jonathan Mead.
Yep.
For some reason, he wasn't in my queue, but we took care of him. All right, next up is Michelle Scarberry. Well, she signed in. All right, how about Sylvia Juarez Stinton? I think she called and asked for an adjournment. Billy Kelly? As you know, there's several guys named Billy Kelly, but you're Billy Darren Kelly. He needs to be printed also.
That sounds like it's.
All right, very good. This file number is 26169SM. All right, let's see if I can find your case. There's about 80 cases in here this morning, but you're here. Mr. Kelly, they charge you with a retail fraud second degree. They allege that on February 1st of 2026, you were at the Walmart store and you took some property that was worth more than 200, but less than 1,000. Allege that you took you brought in your own reusable bags, allegedly. They knew you from previously. They allege it was $313.30, 57 items. They requested a felony retail fraud first degree, but the court authorized only misdemeanor charges. They indicated Connie Berger was driving the car. I don't know if she got charged or not. Mr. Stickley, you think we should get counsel here?
I do. It would be appropriate here, Your Honor.
That's annoying. Can you turn that off? Oh. Vivian, I'm going to mute your microphone for a minute. We're getting some feedback from your. All right, I think that's better. Are you still at 9th Street?
Yes.
June 5th at 8:30. Appoint an attorney. You're barred from Walmart for the time being. They have a video of this, so when you get with your attorney, you may want to request the video, see what that shows, and see what we're going to do. All right, you go with the court officer, and he will take you out to get counsel. Now, is Michelle Scarberry back? She did check in, or at least get her name written down. What's your name, sir?
My name is Ted Sloan.
I'll be checking on. Anybody here for prelims with Attorney Strong? I'll be checking on.
Good morning.
Morning. I just received documents this morning.
That's what I understand. There's a new protocol that I just learned of yesterday, and we'll do the best we can. You're always on top of your cases, so we're going to be.
Pre-talk to everybody who's had contact with, and now that I'm.
All right, thank you.
Do we have advice on that?
All right, Vivian, would you come back to us for a moment?
Yes,
Which case are you here on?
the Guadalupe Villafuerte.
That would be Casey Strong. I'm not sure what her status is. She just checked in, so stick with me. It may be a minute. This is the first day of our new utilization of the historic courtroom, Vivian. We got all kinds of bugs we're working out here. So stick with me.
Okay.
All right, let's see who it is and isn't here. Delisha Nelson. Michelle Scarberry got her name written down. I don't see her. Angela Scott. Haley Vanderay. Larry Voice. Kyle Wellington. I don't believe all these people aren't no-shows. I think they're lost out there somewhere. Michael Wolf. Delmer Wood, someone called and said Delmer is in the hospital. He has had some significant health problems. I can't believe all those people didn't show up. Would you see if you can locate Michelle Scarberry? What?
What's your name? Angela Scott.
Oh, I called your name. Oh, I'm sorry. I guess I wasn't watching. Angela Scott, would you come back up? Now, the way they've got it spelled, it's Angala. Is that right?
Yes.
But it says, but it's Angela? All right. I should know that. You got a ticket for driving with no valid operator's license and no license plates. We get lots of these. I call it driving while poor. These are under Three Rivers ordinance. I just lost Mr. George. Driving without a valid license is a misdemeanor. It's punishable by up to 90 days in jail, fine of up to $100. Carries 2 points. And it goes on your driving record. Improper plate. Scott stated she knew it belonged on a Tahoe. She stated she had no license, but believed she had a right to travel. Let's see if I can get Mr. George back here to help me. Well, did we find Miss Scarberry? Like I said, we got logistical issues of getting people up here. There's one small elevator. One thing, this courtroom didn't have an elevator when it was in use. The whole time it was in use as a courtroom, there was no elevator. There was a narrow wooden staircase full of stacks of paper from the clerk's office, which would be where the fire would have started if this courthouse would have burned down. That was theoretically a fire escape. All right, apparently she is here and she's getting printed. And I lost Mr. George, so I don't know where to go with Miss Scott.
He'll be back, but one brief suggestion, Your Honor, and I don't, maybe we can address this another day, but maybe we can operate with that door closed, or maybe it's just me, but it's constant like.
All right, good morning, Daniel. We could try that. I don't, but every time they open and close it.
Oh, I guess the door, yeah.
We'll see how that's gonna do. So, well, let's try it.
All right, well, they figure out what to do with the door. Good morning once again, everybody. TCF Live. My name is Dan. It's good to have you here. So there are a few other things going on out in Courtlandia, but to be honest, none of it is overly compelling at the moment compared to Judge Middleton in his new old courtroom. So we'll continue to ride here for a little while.
Morning's just gonna get more busy. Miss Scott, you live in Marcellus?
Yes, sir.
Let's take a look at your driving record. You don't have any points. you have $1,071 of unpaid fines. No valid ops, no valid ops, no proof of insurance, no proof of insurance. Back to 2021. So you could go to jail for this because you keep driving and you don't pay the fines, and there's a right to travel. There certainly is, but there isn't a right to drive.
Can I do a payment today, Your Honor?
What's that?
Can I do a partial payment today, Your Honor?
Well, I could wipe these out with a jail sentence if you'd like. You could just do like 10 days and I could wipe out all your fines.
No, I have a whole family, I can't just.
Yeah, I bet. But yeah, you keep getting tickets and not paying them, then you keep driving. I call it driving while poor, which isn't meant to be an insult, but people don't have enough money. No insurance, no plates, often go hand in hand. But you've been driving without a valid license for,
I've never had one, Your Honor.
you never had one, and
I
you
was
got,
supposed to be going this week to get one.
all right, so you planning to go get a license?
Yes, Your Honor.
All right, well, let's try that.
it. Maybe we could set up for a pretrial
Yes.
after, after our drop dead May Day.
Where do you work? Do you work someplace?
I'm self-employed. We do wood during the winter and then we just stock up on the summer and they just sell it throughout the year.
Well, there's plenty of wood that's been fallen. This is Angela Scott, Mr. George. She's got an ordinance charge with driving without a valid license and no plates. She got $1,000 worth of previous unpaid tickets. Some of it's a booking fee, so she got about $800 worth of unpaid tickets. She would like to try to pay on the old tickets, and she says she has an appointment. Tell me about your appointment with the SOS. Have you actually made an appointment?
Yes, it's for, I'm pretty sure it's for this coming Wednesday at the Bureau over there in DeWatch.
All right. In the old days, they wouldn't give you a license if you had unpaid tickets. They called it fail to comply with judgment, and they would suspend your license for unpaid tickets. They don't do that anymore, but you have some old Cass County tickets that might be jamming you up also. I agree, if you got unpaid tickets, they shouldn't give you a driver's license.
I think I paid the ones in Cass.
All right. But they changed the law. So it would be great if you could come in here and show that you have a valid license and valid plates. So I'm going to continue this for a pretrial. I don't have a calendar here. This bench hasn't really been set up good for me yet. So let's see what we got. I'm going to set this for a pretrial when I don't have prelims and pre-exams. I'm going to set it for May 26th. said, this isn't ideal, but we'll work on it. Did you end up cutting a lot of wood after the tornadoes?
Yes, we did, actually. I was surprised. And there's still so much wood on the sides of the road. It's crazy.
Yeah, all you can do is just pull up and throw it in your truck,
Yeah.
and they'd be happy to get rid of it. This will be a Tuesday, May 26th. 2026 at 8:30, courtroom C, pretrial conference. Mr. George will be here to bring license and plate info. You're on the driving suspended merry-go-round. It's hard to get off of it. So I want you to go to the SOS, do what you need to do. Even if you only get your temporary permit, bring that also. All right, you're good to go.
Thank you, Your Honor.
All right, friends, we will keep an eye on Judge Middleton's court, maybe come back later, but there are other places we can go now. Let's stay in Michigan, but let's say good morning to Judge McNally.
My client just needs to my medium right. You say change correct, sir?
Is anyone in the back?
Give me 1 second. I'm curious as to what prompted her or him to come in here. or her
It's,
to come in.
I misspoke, Judge, it's,
Right. What prompted her to come in today?
Your Honor, she had,
I remember this one. You know what? That's pretty amazing, isn't it?
I say I already told him, I already know I'm about to get scolded.
Get a scolding. You haven't been here in 3 years. If you call that a scolding, I call it disrespectful for you not to show up. But I remember this case, and that's never a good sign. 3 years later, I remember this case because your attitude was, and now you've seen the light. Where's she been for 3 years?
Your Honor, she is now gainfully employed in college. She had a period of time where she did not have any lodging, and she's gone through an ordeal, but it does appear that she's made some positive strides. And she's not arrested on a new charge or anything. In fact, she called the police for assistance, and it was at that time they discovered that there was not a standing warrant, but she's not getting picked up on a new case.
Is Heather here, Jennifer Wiseman?
Yes, she is, but I can pull something up if you need me to.
And pull this case up.
Go ahead.
I
Do you have
sensed
the case number by chance? I can.
23W 831 736.
Thank you.
So I sentenced her, it looks like, back on June 21 of 23. I set a review hearing. Well, then she failed to appear on October 2nd. It must have been a show cause. It was a show cause. So let me find that show cause and we can go from there. I don't know. Okay. The charge is failure to pay fines and costs is ordered. This is part of a show cause dated September 18 of 23. So have you had a chance to look at that with her or talk to her about that?
No, Your Honor, I saw that there was an outstanding fine, I believe, and that there was just a lack of all terms and conditions. I was more concerned with the amount of time that's elapsed since the last show cause.
So I'm gonna arraign her on that. And then I'm gonna go from there, okay? Ma'am, you're charged with failure to pay fines and costs as ordered. This is part of a show cause dated September 18 of 23. And you didn't show up. That's your first technical violation. However, now you've absconded, so that means that your height of status could be revoked. I don't believe I ever revoked that status. The conviction entered, and you would be subject to a 90-day jail term. Do you understand?
Yes, sir.
You are presumed innocent. They have to prove you guilty by a preponderance of evidence on this, since it's a probation violation. You have the right to a hearing. At that hearing, you have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty at any time, you'll be giving up all those rights, and we're not going to have a hearing or a trial of any kind. You understand that?
Sir.
All right. You understand at a hearing, you could testify or remain silent. If you remain silent, that silence would not be held against you, and you'll have the right to cross-examine any probation witnesses. I can't hear you.
Yes, sir.
All right. So in a second, I'm going to ask you how you wish to plead. Is she going to plead guilty or?
Yes, in these circumstances, it's a black and white situation. She knows that she did not make a payment, and she knows that she failed to appear. I don't believe that the hearing would be necessary that, but we will be wanting to provide an explanation. But yes, in the circumstance, we're not contesting those two scenarios.
John Colin, Beth, to the charge that you failed to pay fines and costs totaling $935. How do you wish to plead?
Guilty.
Did you fail to pay?
Yes, yes.
I can't hear you.
Yes, sir.
Anybody force you to plead guilty?
Just ready to go ahead. Just trying to get this. That's the church.
Plea is accepted to that charge. I find it to be an accurate plea made voluntarily and understandingly. Here's my concern with you. I bet you didn't do the community service either. And I bet you didn't do the positive strategies program either.
Definitely did community service and a positive strategy.
Let me,
And I sent her emails, and that's why I had tried to contact her.
just keep your voice up.
I just tried to contact her on email and just let her know, like, I couldn't make it. So I was just trying to, let y'all know so y'all can another date or just so I can get here. And I couldn't, and it's like everything just fell apart and I couldn't even get here. So
You couldn't get here.
it really was after the fact, and I couldn't get up here and what was going on with my life, honestly.
When you got here to this, you got here to the Speedway on Allen Road in Woodhaven, and Allen Road's right next to us.
Yeah,
That's when you committed the crime back in February of 23. And then I heard all this from your lawyer and you about how your employer, right? Correct me. These were lottery tickets. Yes?
Yes, but I'm not gonna lie. I feel like they just, honestly, I feel like they threw me under the bus. I wanted to take that trial. I didn't know how and what to do. And honestly, I was scared. So
You were what?
I feel like they threw me under the bus because it wasn't me doing it. It wasn't me doing it. So and they wasn't giving y'all no cameras or footage, anything, and I didn't know how to go about it. And no knowledge, none of that. So of course I was angry. I was scared. I didn't know what to do. I didn't know what to say.
I wouldn't have taken your plea if you didn't admit that you would. Ms. Murphy was representing her. I remember this vividly. And she was saying that at least initially that the employer asked her to steal, her boss asked her to steal the lottery tickets. That's what I was told. I'd love to go back and listen to this. I mean, I give myself credit for even remembering any aspect of this, given the fact that this all happened 3 years ago, and I've only had probably 8,000 people in front of me since then. I want to know why she didn't show up. And I want to know why she didn't come and ask for time to pay when I told her she could do that.
I really ain't had I didn't have nobody, I didn't have nobody to tell me that this is what you gotta do. If you don't do it, you definitely gonna go to jail. I done been through so much since I haven't been here, so like, I got a lot of knowledge now. I go to school for criminal justice, so I know there's certain things that you have to do, but there's certain things that you just gotta.
You're going to school where for criminal justice?
Oakland Community College. Yeah, I'm about to graduate actually.
With an associate's?
So
You have proof of that?
it's on my phone. I got everything. I got a FEMA certificate. I got the first year already. I think.
Your name?
Elizabeth Lost Probation, Your Honor.
Did she do the positive strategies program in the community service?
She did do her community service, Your Honor. She did not attend the Positive Strategies program. She indicated, to me that she was struggling financially. I actually worked it out with PRS. They waived a lot of her late fees and courtesy fees, so she could attend that program, but no, she did not end up attending it.
Ma'am,
Yeah, the last communication from PRS was that, she wanted to share another update with me. She had to reschedule her session from the night before, waived her fee as courtesy. Unfortunately, she failed to attend the scheduled session again. That is from Kristen at PRS.
Jennifer, give me a new Woodhaven date real quick.
Sure.
Let me just double check something. How much trouble have you been in since you were in front of me? Oh, you went out and got something else. You got a CCW dismissed because it was under HIDA.
Yeah, it was.
You still have warrants. Let me see how many warrants you have here.
I didn't have no CPU on
Here's what you have. Warrant out of the 24th district, warrant out of the 23rd, 23rd, 53rd, 37th, 46, 36, 36, 36. You got about 8 warrants out.
right now.
They just ran this today.
What? I don't know. I only thought I had the ticket warrants. I'm not even aware. I'm not even what's it called. Like I went on my I needed my driver's license. I literally got to pay 2 no insurance tickets, which I did have insurance. I just
Ma'am,
didn't get.
let's stick to the issue.
Yes, yes, sir.
Do you work?
Yes. I'm okay. I've been working here for 4 months. Going on 4 months. Be here every day. Thursday, only day I don't be there because I can't work.
Why should I not revoke her HIDA status?
Yeah, I think that, putting it
She
down,
didn't do the positive strategies and she's been blowing us off for 3 years, 2.5 years.
Judge did indicate that I'd be seeking, potentially another day. Woodhaven's here. I think that some of the statements that she's made regarding school, could be verified and maybe that put her in a better light for reconsideration.
You have the money now?
I definitely can pay you good. I can go on my microwave, get you 200, pay 200 today.
Well, you owe us over 900.
Yeah, 935.
No, you owe more than that now. There's warrant fees and everything else. You came here after 3 years and you came here with only $200 when you knew you owed at least 900.
I don't get paid till Friday. Sorry. I don't get paid till Friday. And then I just gave my auntie rent money, so
Give your auntie what?
rent money, so I didn't. Listen, I got a lot. I still got a lot going on. And I want to get this out the way. I'm not gonna lie. I definitely trying to get this out the way. I definitely told him I'm trying to get this. So, you know, I'm trying to, because I already know. I knew this was gonna come back to me. I didn't know it was gonna come back today. And I should have been got it together. And that's just me not having, you feel me? Yesterday was my daddy death day, so it's not like I feel me. Everything just fell apart. Like when me getting off work at 3 in the morning today, like.
I know, but you remember what an attitude you had with me?
Yes, and I apologize, because I was a kid, didn't know nothing.
Well, you act like you've grown up by 28 years. This was only 2.5 years ago. You were born in 03, right?
Yes, sir.
I'm not amused.
I don't, it's not like I got any items. I don't got nobody to look up to. I gotta do some.
Where's your mom and dad at?
Dad passed, so, and my mom, really don't, really.
I can't hear you.
Dad passed, so me and my mom are not cool, so.
You're not cool? You don't get along?
Very.
You're not showing her enough respect.
No, it's not like she give her kids that type of respect, you know? You know how these generation mamas be. Wanna do what they wanna do. I take care of their kids and treat them and show them the right way.
Here's what I'm gonna do. Jennifer, give me a date when Mr. Urick's on my docket, will you please?
You've got April 29th or May 13th.
Beth,
Yes,
positive strategies program.
yes.
How long until she could get into that?
I honestly, I'd have to look at the website. It's offered, about once every about 4 or 5 weeks. I am honestly gonna go off memory. I wanna say it's being offered like the second Thursday in May, like May 13th, maybe. I'm
Give me
again,
a later date in May.
The 27th.
And how many days is that program again? It's just,
it starts with the initial.
right, but I didn't order any follow-up, so it should just be one day, right?
Yeah, it should just be one day if no follow-up was
We're
ordered.
gonna set a sentencing for, what'd you say, Jennifer?
May 27th.
At 8:30 in the morning. Now, I'm setting a $200 cash bond. I'm accepting your guilty plea. I'm gonna write down here, defendant 2, attend positive strategies program. Let me tell you something. If you're truly, and bring proof, you bring proof. Bring proof,
Bring it out.
defendant attending criminal justice program at Oakwood Community. Oakland Community, I'm sorry. Listen to me pardon me?
This is literally my last semester. I'm supposed to graduate on.
Well, I tell you what, you can take a criminal justice degree and pretty much throw it down the garbage if you're convicted of things like this in CCW. Now you got the one off your record. And you better go over and take care of at least a couple of these warrants. So I'm giving you 6, 7, 5 weeks here. It's going to take care of at least a couple standing warrants.
I didn't even know I had it. You know what I mean? I don't even know how.
So even though you were wise with me and disrespectful, that's the beauty of the criminal justice system. I'm still gonna treat you fairly. You're gonna post $200. Jennifer, tell Heather or whoever to
I
print out a
am
note.
relaying it right now.
Thank you very much. May 27th at 8:30. Take care of a couple tickets. Do the positive strategies program, and you better come back with all the money here too.
Yeah,
Listen, this is it. I can't extend probation anymore. So you gotta come back with, there's restitution of $300. So you're gonna be able to come back with the other 700 in 4 or 5 weeks?
I'm not gonna lie. I was about to just ask you, like, can I pay it through the 7 weeks? That's what I was doing.
I can't do it.
So you just want me to come order?
You have to.
Yes, sir.
If you want this off your record, you have to,
Yes, sir.
okay?
Sir,
In fact, if it will help you, just wait 1 second. You're mumbling. Just let me finish, please.
I'm just happy. I'm sorry.
Happy.
But like, I'm just tired. Sorry.
She did this before too. She won't stop talking.
That's my part. That's what I'm in therapy for.
Court will consider not requiring you to take care of other tickets. I mean, you're still gonna have to do it. If D comes with all money. I can't dismiss this for you if I don't have all the money. I can't do it. You had 3 years, 2.5 years to save. That's all I can tell you. Post your bond. Good luck. I wish you well. I hope I can dismiss this for you. Good luck. Thank you.
Thank you, Judge.
Thank you, Judge.
Good morning, Judge McNally. If you have a second, I just wanted to introduce you.
Sure, come on up. How are you?
This is Miss Laura. She just started a couple weeks.
Come on up. This way, right here, right here, right here, right here. Yeah, walk right in through that door there. Come on up. Absolutely. You started with the prosecutor's office?
Yes, I did. Miss Sarah.
Nice to meet you. Is that your person?
Yes, Fargo.
Barda?
Fargo, like the bank.
Oh, okay. How you doing? Nice to see you.
You.
So you're starting in the prosecutor's office?
Yes.
And where are they gonna have you?
General screening.
Okay,
Probably.
good.
Like
You
our-
passed the bar, right?
Yeah. I just took it in February, so I'm waiting for my results. They come out real soon. We're gonna find out if all the BCs are. Yeah,
A week or two.
I check them every day.
You passed. Don't worry about it.
Thank you. I just one of the PCs, she actually reached out to me asking what she can do. A lot of the PCs, like, some of them don't do that. I was like, I was the only one who used to do that.
Right.
So I definitely think she's gonna end up being really, really good.
I'm sure you
Yeah.
are. I'm sure you are. Well, it's nice to meet you. I hope to see you around here.
Anyway, sorry to stop your dog.
You're fine. You're fine. Thank you very much. Nice to meet you.
Okay, well,
Take care. All right, where's that one with Mr.?
All right, friends, let's head down to Florida. Say good morning to Wade Mercer.
And one count of tampering with a witness. Mr. Johnson, I read the complaint. There is probable cause for the charges. I've also looked at your criminal history, and I think I saw where you, I don't know that I wrote it down. Marijuana conviction in 2019. He's been to prison before one time. Is that right, Mr. Johnson?
No, sir.
No. Mr. Johnson's criminal history I've got may not be correct. That happens sometimes.
Is it TREVON on the criminal history? Because I know there's a Trevon Johnson that sounds very familiar that may have that history.
Give me a second to look at. I may have the, Mr. Johnson, the criminal history I've got substantial out-of-state charges. Have you ever been charged with a crime outside of Florida?
No.
What about a cocaine possession in Jackson County in 2019? Was that you charged with that?
Yeah, that's me.
Marijuana, end up just being into a marijuana possession, less than 20. 4 years probation in 2023, possession and constructive synthetic cannabinoid.
No. The first one, he said
Yeah, yeah.
2019, that
That's the only
was.
one I saw was the 19 case.
Yeah, I ain't had no possession, nothing else.
Did you get 4 years probation?
Yes, I did.
Did you complete the probation?
Yes, I did.
So it looks like part of the history I've got is correct and part of it is not correct. Well, no, it's the same date of birth. So let me make sure. I'm showing several prior charges. Let's see where this is at. Actually, it's not several. It's a U.S. Army charge.
Oh, that's me,
Cocaine and
yeah.
marijuana, same name, same date of birth. Is that you?
Yeah, that's probably me.
Okay. All right. Mr. Mitchell, anything on behalf of the state?
The only thing I have to say is that we have been in contact with the alleged victim. She even called yesterday. She is requesting contact with Mr. Johnson right now. I told her that, we can't resolve the case today. She understands that, but she is requesting contact. We would be fine if there was no violent contact. We know we'll leave it up to the court to decide what's best for bond purposes, but we just request a reasonable bond, or if he qualifies for a conditional release, we have no objection.
Ma'am, you're the alleged victim. Do you want to be heard, ma'am? You mean to hear from you? Do you want me to hear from you? Come on up, please. I can get some information from you. Stand right here if you will, ma'am. That way he can hear you. You'll be on video. It's Miss Quinn, is that right? Miss Quinn, let me get you to raise your right hand. Do you solemnly swear or affirm the testimony about to give in this case will be the truth, nothing but truth, and so help you God?
Yes, sir.
Thank you. So Miss Quinn, you're wanting to have contact with Mr. Johnson, is that right?
Yes, sir.
What is your relationship with each other?
He's my boyfriend and my baby daddy.
Okay, so tell me about, I'm very concerned about the allegations in the complaint. So tell me what happened.
We just started, we started arguing and he did put his hands on me. But he was under the influence. That's not him as a person on a daily basis.
Say that part again, about the daily basis.
He's not that kind of person on a daily basis.
Okay.
He's a very good father, a good boyfriend. He's like the man of the house.
Tell me about this part. Ms. Quinn stated Mr. Johnson then struck her on the right side of the face with a fist while accusing her of cheating. Is that true?
Yes, sir.
She advised he continued to search the residence and returned again, struck her again, this time on the left side of her face and in the mouth. She attempted to get away from him and told him to stop. Is that true?
Yes, sir.
She eventually was able to break away, retrieve the phone, and run into a separate room. She closed the door and used her body weight to hold it shut while calling 911.
Yes, sir.
She reported that Mr. Johnson pushed against the door, forced entry into the room, grabbed the phone while she was on 911, disconnected the call, and left the residence with her phone.
Yes, sir.
All that's accurate.
Yes.
Anything else you want to tell me?
No.
Okay. Mr. Mitchell, anything from the state?
Not at this time, Your Honor.
Mr. McDaniel, any questions for Ms. Quinn?
No, Your Honor.
Okay. Thank you, ma'am, for being here today. I'm going to deny your request for contact. I have concerns about your safety, plus his criminal history is not good at all.
That one charge is the only charge. Well, those two.
You're not, no, ma'am. There's other charges I didn't even get to also in the other state. That you may not know about. But in addition, in Texas, Bell County Jail, criminal trespass.
Yeah.
Yeah, every time I add something, he remembers now. So the request for no contact is going to be denied for your own safety. Okay.
So what can I do?
You can't have contact with him, at least not right now. Mr. Mitchell's office will get the case. They'll decide what to do, but
I don't want to press charges.
doesn't care, no matter what you want. The state has an interest in protecting you and especially protecting a child in that environment. So the request for contact is denied temporarily. Okay. Thank you for being here. Your bond amendment, Mr. Johnson, your bond's going to be set at $5,000 on the felony, $2,500 on the misdemeanor. You have a condition of no contact with the alleged victim. You also have a condition of random urinalysis as part of your bond. And it's cash or surety, sir. Mr. Johnson, you have the right to post the bond. You'll get to use the phone in a few minutes, sir, but you can have no contact with the alleged victim at all. Now, Mr. Mitchell's office will get the case. They will hopefully interview the alleged victim and be thorough about it. And then they'll decide whether or not they're going forward with the case. If they decide not to go forward with the case and they dismiss the charge against you, the no contact condition goes away. I can't keep a no contact condition in place if they're not going to go forward with the case. However, if they decide to go forward with the case, the no contact condition would apply at least for the foreseeable future, unless myself or Judge Garcia modify it and change it. But right now, no contact. And I'm going to ask the jail to give you a notice for your court date. That will be
The 5th.
May 5th at 8:30 will be your court date. Mr. Johnson, do you have any questions?
Why my bond so high?
Because of your history, it's a pretty standard bond for
I don't
third-degree
have a
felony
history,
and a
sir.
misdemeanor. You have multiple prior charges. I just
Out
gone
of
over them
state.
with you.
Out of state.
Don't care. I don't care if it's out of
2019.
country. You still have criminal history. It doesn't matter where it's at. I couldn't hear. Did he say what I think he said? Corporal, you come up to the microphone. I think he just said that's bullshit. Is that what he said?
I didn't hear him, sir.
No, you didn't hear that, sir.
I'm asking the corporal what he heard. Corporal.
I didn't hear anything. I was over there writing. I didn't hear him say anything.
All right, Mr. Johnson, I'm not positive I heard that. I think I did. If I had heard it for sure, I'd have a contempt hearing, but I'm not gonna, I'm gonna give you the
All right.
benefit of doubt. You get to use the phone in a few minutes. Have a good day.
You too.
Have any questions, ma'am? This case is Patsy Laudman. And your relationship, so I can tell her who's here. Her mother and siblings. It is siblings, it's not boyfriend. Ms. Laudman, good morning. You're here because you've been accused of one count of grand theft of motor vehicle and one count of resisting an officer without violence. Ma'am, there is probable cause for the charges. Ms. Laudman, the criminal history I've got in your case is excellent. It shows no prior criminal history. Is that accurate, ma'am?
Yes, I've never been in trouble, sir.
Okay, that's great. I'm going to appoint the public defender's office to represent you for first appearance purposes. I'm going to ask you to listen to Mr. McDaniel, your attorney.
Your Honor, this is not a typical grand theft. I mean, I guess a rental vehicle that her brother has, when I suspect it's in there. And the resistance is kind of shaky also, but, we just asked for some kind of reasonable release option and should accept the conditional release.
Mr. Mitchell.
Your Honor, there are similar circumstances with the alleged victim in this case. They've been in contact with both me and Mr. Bassford since he's here today, requesting that they have contact. I told them that we would address the case at a later court date, but for today's purposes, they're just requesting to have contact. We would recommend no violent contact or peaceful contact, however you want to put it. And if she does qualify for a conditional release, no objection from the state.
So the no violent contact would apply if it was a crime of violence to begin with. So it's a theft crime, so you're not opposed to contact.
Not opposed to contact in this manner, and I don't think.
So
You want contact? Yes.
So can't hear you, ma'am. Y'all live in the same house? So, Ms. Laudman, given your lack of any history, I'm gonna let you pick between a bond and a conditional release. If you like to post the bond on the felony charge will be $5,000. The bond on the misdemeanor, actually, the bond on the felony charge will be $2,500. The bond on the felony will be $2,500. Your total bond is $5,000 cash or surety, but I am going to offer you a conditional release because of your lack of any history. The standard condition of no contact will not apply in this case because it's a grand theft charge and because it's your brother and because your brother's wanting to have contact. So you can still live in the same home, but you would be on conditional release as long as the case is pending. The jail would give you a notice for your next court date, which would be May the 6th.
5th.
May the 5th at 8:30. Do you have any questions about that choice between the bond and the conditional release?
No, sir. They
Which one
explained to-
I'm sorry?
The conditional release.
Okay, I'm gonna grant you the conditional release. So what that means is the jail's gonna let her get dressed and then they're gonna bring her to the courthouse. The conditional release office is the same as the county probation office, which is downstairs inside the county judge's office. Same entrance. So it should be there probably 30 to 45 minutes. When she gets there, she'll meet with Mr. Goodson or Mr. Ham, one of the release officers. They'll explain the release to her. They'll give her a copy of all the rules in writing and she'll be free to go. So someone's gonna be able to pick her up in 30 to 45 minutes. Your family will be there to pick you up, ma'am. Any questions?
No, sir.
Have a good day, ma'am. Next case is Christopher Hogan. Mr. Hogan, good morning. Mr. Hogan, you're here because you've been accused of one count of disorderly intoxication. Mr. Hogan, there is probable cause for the offense in your case. I'm appointing the public defender's officer to represent you. I'm going to ask that you listen to your attorney, Mr. McDaniel.
Your Honor, I spoke to Mr. Hogan. We're going to enter no contest. The charge is listed. You understand it? Be sentenced to 60 days in county jail, 2 days jail credit, $370 fine. Yes, sign this plea waiver form, waiving his right to jury trial and call witnesses.
Thank you. Mr. Mitchell's at agreeable with the state.
It is, Your Honor.
Mr. Hogan, did you hear that agreement, sir?
Yes, sir.
Mr. Hogan, any questions about that agreement?
Seems a little harsh, but hey, we're gonna do what we gotta do, so let's do it.
All right, Mr. Hogan, I'm going to accept your plea of no contest to the charge of disorderly intoxication. The judge of guilty sentenced you to 60 days in the county jail with 2 days credit. 370 court costs and fines are imposed. The reason for that sentence, Mr. Hogan, is your criminal history is probably 50 pages long. So, Mr. Hogan, I do wish you the best, sir. No probation involved. You finish this jail sentence, you're through with this case. Any questions, sir?
No, sir.
Wish you the best, Mr. Hogan. We have Tyler Langford. Mr. Langford, good morning. Mr. Langford, you're here for first appearance accused of violating the terms of your county probation in 25-544 CT. Mr. Langford, I'm appointing the public defender's officer to represent you, and I'm asking that you listen to your attorney, Mr. McDaniel.
Your Honor, I spoke to Mr. Langford. We're going to admit that he violated his probation, understanding 30 days in the county jail, 1 day jail credit, and whatever remaining fines are.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
And Mr. Langford, did you hear that agreement, sir?
Yes, sir.
Do you have any questions about that agreement?
None reasonable.
Is that the plea you would like to enter?
Sure.
Mr. Langford, I'm going to accept your admission that you violated the terms and conditions of your probation, revoke your probation, sentence you to 30 days in jail, but you have credit for 1 day that you've already served. You also have court costs and fines remaining in the amount of?
Judge, he has a $360 fine balance. He was on probation for 2 offenses. He was on probation for a first-degree misdemeanor driving while license suspended and a second-degree count two was second degree misdemeanor, no motor vehicle registration. Is it going to be 30 days on each to run concurrent?
Yeah, thank you. Mr. Langford, your sentence will be 30 days on both cases, but it'll be running at the same time. So it's one 30-day sentence with credit for 1 day on both of them. Knowing that, Mr. Langford, is this still what you want to do?
Does that change anything?
It doesn't change your release. It doesn't change your release date. It doesn't change anything. It's just, we have to take care of both cases and get both of them out of there.
Okay, there's no felony, nothing like that? Okay, yeah, that's fine with me.
Yeah, I don't want you to finish one sentence and have probation left on the other. I want you to be done with it, okay?
So I'll be off probation after this?
Correct.
Really? Oh, yeah, let's do it.
So, Mr. Langford, that'll be the sentence. Mr. Langford, you have 29 days left at most. Now, the reason I say at most is hopefully you're going to get some gain time under Florida law and get out in less than 29 days. But either way, there's no probation involved. Mr. Langford, I wish you the best. Any questions?
No, sir, thank you.
Yes, sir. Have a good day. After Mr. Langford, we have Zachary Dixon. Mr. Dixon, good morning. You're here for first appearance for an out-of-county warrant out of Bay County. I took a look at what we got from the Bay County Sheriff's Department, and their information shows a violation of probation warrant with no bond. So you'll be held for Bay County. Mr. Dixon, you'll get down there hopefully in the next couple of days, possibly even today. But when you get to Bay County, you'll go to another first appearance, and that judge will address your bond status. But the bond we have right now says no bond. Any questions?
No, sir, thank you.
Yes, sir. Wish you the best, Mr. Dixon. Sharmalis Lewis. Mr. Lewis, good morning. Mr. Lewis, you're here for first appearance. You've been accused of 3 new charges. You've been accused of 1 count of aggravated assault with a deadly weapon, 1 count of possession of weapon or ammunition by a convicted felon, and 1 count of tampering with a witness in a felony proceeding. Mr. Lewis, there is probable cause for the charges. It looks like you got out of prison in September, which would be about 7 months before this incident, 6.5 months. I'm going to appoint the public defender's office to represent you, Mr. Lewis. I'm going to listen to the attorneys, and I'm going to set your bond. Mr. McDaniel, anything?
No, Your Honor.
Mr. Mitchell?
Just a second, Your Honor. I'm double checking. Not the present state, Your Honor.
All right. Mr. Lewis, I'm going to set your bond at $7,500 on the 2 third-degree felonies. That's the ag assault and the tampering. $15,000 on the possession of firearm by a convicted felon. Your total bond, Mr. Lewis, is $30,000, but it's cash or surety. That's important because that means you don't have to come up with all $30,000. You can go through a bond with Mr. Lewis. Mr. Lewis, you've got a condition of no contact with the alleged victim as part of your bond, and you will get to use the phone in just a few minutes, sir, to try to post the bond. Your court date will be May 5th at 8:30 will be your court date, Mr. Lewis. Any questions, sir?
No, sir.
All right, Mr. Lewis, wish you the best, sir. And we have Edrick Smith. Mr. Smith, good morning, Mr. Smith. You're here because you've been, let's see, you've been accused of 1 count of a new battery in a second or subsequent offense. That's case 26-181 CF. And it looks like you're already out on bond in 25-305 CF. So I'm going to appoint the public defender's office to represent you for first appearance purposes, and we're going to listen to the attorneys, and then I'll address your bond status. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell?
Your Honor, right now I'm sending an email to Ms. Bennett. Karen Bennett, she represents him in the 25305 CF case. As of right now, we're requesting. Was it?
She'll see today. They got a hearing today. They got the pretrial today, so.
So, Mr. Smith, I'm going to set your bond at $10,000 in the new battery, which is 26181 CF. By condition of no contact with that alleged victim, I'm revoking your bond in 25305 CF, but we'll see what happens today. Y'all may work something out today. I have no idea. But if you don't work something out today, your bond's being revoked unless Judge Garcia makes a different decision. She's the presiding judge in that case, so she may do something different than that. So really, it's going to be up to her. But unless she does something different, I'm going to revoke your bond. So, Mr. Mitchell, see what happens in felony court.
Yes.
If she does something different, then that's her call. But otherwise, send me an order revoking his bond, please.
Yes.
And Mr. Smith, I believe there's a condition of random urinalysis. I know there is on your bond. So let's go ahead and get a urinalysis from him, Corporal, after first appearance, because Judge Garcia would like to see that, I would imagine. Mr. Smith, you do have the right to use the phone, sir, in a few minutes to contact friends or family about the bond and let them know what's going on. Any questions, sir?
No, sir.
All right, Mr. Smith, wish you the best, sir.
What was the bond in the new law case?
10,000.
Okay.
I think I said no contact with alleged victim. I know I did.
Yeah.
All right, Mr. McDaniel, that's everything I had on my first appearance list. Anything else from the Public Defender's Office?
No, Your Honor.
Thank you. Corporal.
Okie dokie, friends. Good morning once again, TCF Live, now entering hour 2. Morning once again flying by. My name is Dan. It's good to have you all here with me this morning. So I promised you in the chat a couple of special, new, different, fun kind of things. First off, we all know Dungeon Court, and we all know the lore of it. But have you ever wondered what happens in Dungeon Court when the lights go out? Well, it turns out that the spirits of Dungeon Court have managed to turn on the live stream. You are looking live at Dungeon Court right now. This is what it's like when all the lights go out. I'll just let you listen in for a minute, and you tell me if you can hear the spirits of the dead. Now, I don't know about all of you, but that's quiet, almost too quiet. I'm concerned that something might be going down there, so I will keep an eye on it. For those of you who have no idea what that was just all about, Dungeon Court is our guilty pleasure that we experience during the 4th hour every Friday here at TCF, so be sure to check that out. It's good times. Here's the other thing I've got for you. So we know that Judge Middleton streams his court out of the 3B District Court in St. Joseph County, Michigan, but he alluded a month or two ago that Judge Pattison would also start streaming because of the fact that they've been relocated. So guess who's streaming this morning? Judge Pattison. We've never watched him before on this channel because he hasn't been streaming, so let's go there and experience something new.
Ray Clark. Mr. Clark is here today with his attorney, Mr. Truckee. The people are represented by the Chief Assistant Prosecuting Attorney, Mr. Gabriel. And Mr. Frazine is here from our probation department. And this case started out a few different charges, and I believe the plea on February 20, 2026 was to assault and battery. And then Mr. Frazine prepared the pre-sentence report with a recommendation. I think what we'll do is let you, Mr. Frazine, lead the way, and it might be helpful for you to be fairly detailed. And hold on. Just 1 second. All right, yeah, so if you can be fairly detailed, why don't you lead the way, Mr. Frazine?
Thank you, Your Honor. Let's go with Mr. Clark. He's 44-year-old male living in White Pigeon, helping with his mother, helping her out. And this involves a incident at the Harvey House, May of 2025. Started over his adult daughter, her relationship with Mr. Hernandez. Aubrey Clark is in a previous relationship between Mr. Clark and Lindsay Lewis, an ex-girlfriend. They are no longer together. He graduated from education and is currently employed at Sturgis and Molding Products in the maintenance department. Mr. Clark relayed that he does not drink very often, maybe once or twice a month. He does drink his Monster and vodka. He did say that he smokes marijuana on an infrequent basis, and he did struggle with meth use in his 20s and 30s, but he has been clean from that for well over 4 or 5 years. He does have COPD, which he contributes to some of his previous lifestyles. This officer does not think, from the evidence I saw and the police report from speaking to Mr. Clark, that drugs or alcohol was an issue in this case. Mr. Clark did state that he attended a 10-week MAP Michigan addiction program in Sturgis for his 2003 probation for marijuana. Other than that, he has had no other involvement with the criminal justice system up until now. He has never suffered from anxiety or depression or engaged in any other mental health services. Mr. Clark relayed that this incident, which was in May 3rd of 2025 at the Harvey House against Leonardo Hernandez, was a result of multiple assaults on his daughter Aubrey. The last one, which took place just a few days before this. His daughter has rods in her back due to severe scoliosis. And about a year ago, Mr. Hernandez and his daughter were living together. He struck her because she allegedly cheated. Mr. Clark spoke with Mr. Hernandez. He said he was fairly calm that time, and they came to an understanding that that was not acceptable. Mr. Hernandez had told him that he would never strike his daughter again. Then approximately 3 to 4 months later, there was another incident, and this time she had to go to the hospital. Unfortunately, like many domestic victims, she lied about what happened, and Ms. Clark blamed herself for causing Mr. Hernandez to physically assault her, which again is a classic domestic situation. After years and years of being victims, they tend to almost blame themselves for everything that happens, and so this cycle just kept repeating, and it concerned Mr. Clark. Then a few months later, this happened again. She got some cuts and bruises. He was contacted by Miss Willis, stating that Audrey had again been assaulted. What are they going to do? Then about a few days before this, he found out that she had another black eye. He says he just, as a father, he was just deciding stuff. He tried to talk to her. She wasn't really getting that. She needs to leave that situation, that it was danger to her. So the day of this, he had called Lindsay and told her he was going to the Harvey House and he might need bail money. His intent was to go up to Mr. Hernandez, punch him in the eye, and give him a black eye and say, "How do you like that? How's it feel?" and walk out. He called his brother Jacob because he did not know what he was getting himself into, and asked him if he would go to the Harvey House with him, and he did. He arrived at the Harvey House about 9 p.m. Lindsay and her boyfriend David Jones, who is also pending a charge here, and I will speak to at a later date. They all met up, well, they met up at there, and he went and found out his brother James and asked if he'd seen Mr. Hernandez. He pointed to where they were. He went up to Mr. Hernandez and said, "What's up?" He was swinging him. He missed. And then Jacob, his brother, came around the pool table and hit Leo once. Then someone cracked and broke a pool cue over the back of Jacob's head. Leo Hernandez spun around, pulls out a gun, and just haphazardly fires off several rounds. People are yelling, "Gun, gun, gun." As James' brother jumps in, grabs it, wrestles him, the gun falls to the floor. Somebody else grabbed the gun at that point. He wasn't sure who. Mr. Clark said he believes that 4 or 5 shots were fired. People were scrambling all over. One gentleman jumped off a balcony and broke his leg. Mr. Clark was grazed on his side. Another woman was shot in the foot, and the guy that she was there with was shot in the shoulder. brothers and Mr. Jones delivered a few more blows to Mr. Hernandez as they were starting on and us chaos and everybody running around yelling gun, gun, gun. His brother said, or Mr. Clark told his brother, we gotta go, I got shot. They left the Harvey house, drove to the hospital. Police that got there shortly afterwards, speaking about what happened. He pretty much relayed everything he relayed to me, to the officer. He basically said, you know, he'd be hearing from him, and that's kind of where we're at today. Mr. Clark said several times that he could have handled this better. He just said that after she got that black eye again, he just emotionally lost as a father and wanted to protect his daughter as well as get some justice for his daughter. This officer, as a father of 4 daughters, can certainly empathize with what Mr. Clark was feeling at the moment and the desire to protect and seek justice for his daughter. However, as was clearly conveyed by this officer to Mr. Clark, this is not how we handle those things. And that's why we have the law and officers for it. And there's many other ways that this could have been handled. Though he did not make Mr. Hernandez carry a gun to a bar, and he wasn't legally supposed to have a gun, and it wasn't supposed to have while he was drinking, his actions did end up having Mr. Charles Cole suffer a broken leg, Geneva Cole get shot in the foot, Kyle Schrock got shot in the shoulder, as well as Mr. Clark's wound on the side, which just grazed, which easily any of these people could have been killed. He did not force Mr. Hernandez to do those actions, but the choices he made that day set these events into play. And I spoke to him, I said, you never realize a simple push, an argument over a parking spot could easily have someone fall, hit their head, die, or someone pulling a gun and shooting off random bullets. This is why we have laws, and this is why we have to call police and do it the right way, and no matter what we feel like. And he understood that, and he says he definitely would never do something like this again. He just really felt for his daughter. His daughter is now in counseling. Obviously, Mr. Hernandez is visiting Jackson for a few years, so that's no longer a situation. I do believe, I tried to balance this out. There's his intent and emotions and motivation, and then there's the results of the actions. You know, there are other people who were injured because of what happened, as well as his own injury, which all could have been deaths. And then I also weighed that his injury was also a form of consequence. I went back and forth with more upfront jail, less upfront jail. What I came up with, trying to balance all this together, was 12 days jail, credit 2, leaving 10 deferred, a 24-month probation, substance abuse assessment with treatment recommendations, 20 hours of community work service instead of move any more jail, and to complete anger management just to help him manage any impulses he may have in the future and to help protect society as well as himself.
Thank you, Mr. Fraser. Mr. Gabriel?
For police and court, I'd like to wait and allocute after I hear what the defendant has to say.
Okay.
Thank you. I'd like to display a photograph. I don't know, logging into your Zoom, I'm a little less comfortable with that. If you feel like you can see it adequately on my computer screen, that's fine.
It doesn't matter to me, whatever you want to do.
I'd rather keep it off of the Zoom.
Did Mr. Gabriel have a chance?
I see it.
Okay.
That's the daughter that would hug dad when he got home from work, look up at him, pigtails. They would smile on her birthday, blow out the candles. That's the daughter Mr. Clark raised. That's the daughter whose face bruised, bloody. This isn't the only one. This is one instance. This is a situation where a father took a little bit of the law into his own 2 hands. He went to the bar and he punched a man in the mouth. The man that's been abusing his daughter. The daughter at the time was in that cycle of domestic violence where she covers for her, lies to family, hides while she's bruised and healing up. Doesn't make police reports, recants to the police, a cycle you've seen 1,000 times in the lowest judge. Clark's her father. You see a lot of fathers that don't fit the bill. They don't show up, they don't face the court, they don't give a damn. Mr. Clark is guilty here of giving a damn. And he admitted to Mr. Crazy, I should have done this a different way. This wasn't the right thing to do. But boy, if I don't understand why he did it. He approaches this fella at a bar, a place where you're not to have a firearm. This fella is a felon previously, I believe. Another reason he was prohibited from having a firearm. And this was what Mr. Clark wanted to do, was give him a taste of his own medicine. You want to beat up on somebody weaker than you, here's how that feels. There's a time in our country where this would have been just considered honorable. But it's not. We can't have folks taking the law into their own hands everywhere across the country. But the court needs to consider the sentencing considerations, the sentencing philosophies. I don't know. Is reformation relevant here? There's not an indication of a drug problem. There's not an indication of an overarching anger problem. There's not a strong criminal history here. This is the very situation. This face doesn't look that way any longer. Mr. Kilo, the street name, he's in prison now. Shooting a bunch of people this night. And I don't know if reformation is one to consider here. The next consideration being retribution. There has to be a punishment for wrongdoing. One punishment is a marring of your criminal history with the entry of an assault and battery conviction. Another punishment is taking money off of your dinner table. And another punishment is the 2 days already spent incarcerated here. I suspect that deterrence is the bigger one for the court to consider, because of course, courts don't want people settling disputes in alleys and bar rooms and everywhere else. And of course, courts have never wanted that. And of course, it's always happened. So, how the court wants to weigh the deterrence factor, I guess, is up to the court, whether it's going to work or not. I believe individual deterrence is very clearly been made here. Mr. Clark was again recognized the error of his ways while providing a justification. But it just appears that this has been enough. Mr. Clark's taken immediate accountability here. He has recognized that he did wrong. He accepts responsibility for it. I don't know that the recommendations of the 24-month probation or substance abuse or anger management are tailored to Mr. Clark's individual situation. And I wouldn't know if there were several co-defendants here, and this is something that happens. You have the mother of the child who's also a co-defendant who's involved in this transaction. And there's a bit of the, what kind of father are you if you don't? Motivation. That may have been provided from outside sources. So with all that said, I'd like the court to consider just the reality and human nature of this incident. And the fallout was not unforeseeable on Mr. Clark's part, but whether all of the actions that resulted in this bar fight were foreseeable, I do think is a question. Maybe some of them were, but some of them may not have been. So ask the court to consider a sentence of time served, fines and costs, and allow Mr. Clark to move on with his thing.
Thank you, Mr. Truckee. Mr. Clark, is there anything you want to say? You don't have to say anything.
I think he covered it.
All right. Mr. Gabriel?
No, it's too bad, because I was hoping Mr. Clark was going to say he's sorry, and then he understands what he caused. I found it interesting as I read the pre-sentence report that he got a hold of his brother because he wanted his brother to be there too, because he didn't know where he was.
Boo. I hate it when judges do that. Just right in the middle. Oh well. So if you're on the podcast side, the feed just got cut. So, but I do have something to show you. This is from Judge Mogan's court. Apparently, defendants now appear from purgatory, just kind of hovering in the middle of nothingness. So that's interesting. That's just a still shot as he waits for the judge to show up. So we'll keep an eye on purgatory court. Let's do this. Miami-Dade. Judge Glazer.
Car.
And it's not during a riot. I think this provision's for the riot part, so.
Just burglary with a mask.
Burglary, but the property is.
Right, so it may be to both the cartilage and the car itself.
Because he's jumped the concrete wall, appointment, you said refusal, right? What you said review? Appoint the public defender's office. Waive presence bond, what do you want, 7,500?
Yes.
$7,500 bond. So is Mr. Ami here now? He's here, Judge. Great, let's bring him in.
Good morning, Judge Gary Rosenberg on behalf of Mr.
Good
Ami.
morning, sir.
Um,
Let's wait for him to come in.
all right,
Page 7.
so this is a.
1 second, Mr. Ami, you were arrested for a case from July 17th of 2025. The charge is grand theft of first-degree felony, and your attorney is here. You want to announce so he knows you're here?
Gary
He's
Rosenberg.
not
on
on felony
behalf-
bond, Judge. Fine. I think this may predate. I'm not sure.
I'll get the date. So that was an arrest on July 17th.
Of what year? The same as this.
Yeah.
Yeah, it's the same.
Yeah.
No hold. This case is the same date as the open case. So no hold for F25-15233. So it's alleged he's involved in some type of a theft ring, I guess, diverting the transportation of vehicles, and he's involved in the theft of $135,000 2025 Cadillac Escalade. So I believe there's probable cause. What's the bond you want,
So
Steve?
Judge, if your honor looks at his priors, he had 5 years in state prison, and it looks like it was also dealing with auto thefts.
You want the $15,000 bond? It's a first degree felony.
Yes.
$15,000
Judge,
bond.
Judge, if I can just be heard real quick.
You can
Judge,
be heard, yes.
Just real quick, I think that bond is high. Judge Hirsch had allowed Mr. Aim to travel out of the country twice. He did so, came back. He's not a threat to the community. He comes to every court hearing. And this is just an arrest of a case that started on the 17th of July of last year. It is nothing.
What bond do you want?
Judge,
do you
one
ask?
more
I
thing
get
before your honor rules.
Yeah.
He's got an open case in Hillsborough County. It was an arrest from March. And that dealt with a burglary and also grand theft of a motor vehicle. And it looks like those charges were filed.
So why don't you notify Judge Hirsch? You may take him into custody.
I don't know the date of the incident. I just know that he was arrested in March in Hillsborough.
Okay.
I'd
Yes,
ask the court if you could for $7,500 if the court would.
That's fine. $7,500 bond. You have a good lawyer. Listen to what he tells you. Have a nice
Thank you,
day.
Judge. Nice seeing
Thank
you, Your
It
Honor.
was a pleasure. Thank you, sir.
Yes, always, Your Honor. Thank you.
Listen to your lawyer. You got a good lawyer. All right, next we have Taquan Brown. Where is that? We took it.
We did
I
Mr.
did it already.
Taquan Brown.
Pardon. William Fantuzzi.
And it's ours.
Thank you. Page, I don't know. I don't see a page mark here. Is it 14 or 15? 14. Good morning, sir. You were arrested for 3 cases. They are retail theft with a prior conviction from March 5th, another retail theft prior conviction from March 31st, and a retail theft prior conviction from February 18th. I will appoint the Public Defender's Office for you. We'll start with the case F-267763. Sir, in this case, it's from the March 5th case. He's stealing items from marshals. It's $173. Ms. F.
He was convicted in B 20615, and that was for petty theft. And then there's one more. And B 18906, also a conviction for petty theft.
All right, there's probable cause for petty theft, 2 or more convictions. You are ordered to stay away from the Marshall store at 1700 West 49th Street in Hialeah, Florida. Then the bond on this case ending in 7763 is $2,500. Next, we have F-267724 from March 31st. He's taking $461.91 of merchandise. They previously showed me the prior convictions. There's probable cause. You are ordered to stay away from the Marshall store at 901 East 10th Avenue in Hialeah, Florida. The bond on this case is $2,500.
Judge, Mr. Fantazzi does not have funds for a bond. Would Your Honor consider TAP for these cases?
What's your position?
And we got 3 felonies and a misdemeanor, all for theft. Requesting a bond.
A bond of $2,500. And he has another case. The last case, F-267764. This is also from Marshall's from February 18th. $379 of merchandise. There's probable cause for petty theft, 2 or more convictions, $2,500 bond. Have a good day, sir. Next, Casper Lewis, page 15.
And in charge.
Good morning, sir. You were arrested for 3 cases. They are retail theft with a prior conviction and retail theft with a prior, another one, April 4th, April 6th, and April 15th, retail theft with a prior conviction. I will appoint the Public Defender's Office for you. So I guess the correct charge would be what, petty theft, but does it mention any prior convictions?
Correct.
Right, he's got a prior conviction.
Prior.
F-24-25085 for petty theft, 2 or more convictions. That was on February 12th of 25.
So there's probable cause on F-267760 for petty theft, 2 or more convictions. You didn't give me a stay away order from Marshall's. Stay away from the Marshall store at 901 East 10th Avenue in Hialeah, Florida. Bond is $2,500. I gotta write up a stay away.
You sure it's not there?
Can you double
Maybe
check
it's-
and make sure I didn't confuse it with the last one? Both, I don't see it, but I'll write it up.
All
It's no
right,
problem.
sorry.
Then the next case, F-267759. It's here to allege you stole $198.88, April 6th. There's probable cause for petty theft, 2 or more convictions, $2,500. How much was the bond, James? $2,500. Then there's F-26-7758. It's alleged he took, what, $288 of merchandise, probable cause for petty theft, two or more convictions. Their bond is $2,500. Good day, sir.
Alrighty, friends, let's change it up. How about Fulton County, Georgia, Judge McBurney?
All right, Ms. Wood is on. Let me get everyone in the breakout room.
Well, they get stuff lined up. Tim, thank you for gifting 5 memberships. Very much appreciate that. It's very kind of you.
Excellent. They're in there. We'll close that. Okay. Good morning, Ms. Rivers. You ready to take down a plea?
Good morning. Yes, I am.
Great. Well, let's get on the record. In 25 SC 001-819, State versus Linton Greenway. Mr. Greenway is here in court representing himself. Ms. Smith represents the state. Mr. Greenway, are you ready to go forward with your plea?
Yes, sir.
You've had an opportunity to discuss the state's offer with Ms. Smith.
Yes.
You feel like you understand what it is she's proposing.
Yes.
Okay. In a moment, Ms. Smith is going to put you under oath.
Okay.
And then she'll ask you questions about your rights as a defendant, some about the case, and then ultimately she's going to ask you how you plead. When she's done, I'll have some questions for you, and I'll give you an opportunity to share with me anything you want to about yourself or about this case, in the same way that a lawyer would if you were represented by counsel, but you've chosen to represent yourself. And then at the end, I will impose a sentence. If the sentence that I impose is different from the one that you advocate for, and it sounds like, is this a negotiated plea? You think that what Ms. Smith is recommending is what you're recommending?
Yes, that's fair.
Okay, well, if I differ from that, then you'll have a chance to step back and think about it a little bit and say, yeah, that's not exactly what I wanted, but I'm gonna roll with that, or nope, no, sir. I was willing to do what Ms. Smith was talking about, but not what you're talking about, Judge. And no questions asked. You get to leave the courtroom. We don't suddenly grab you, but you'll get a chance to think about it if I differ. I'm not saying I will. I just want you to know that you'll have that opportunity. Okay? All right. When you're ready, Ms. Smith.
Yes, Judge. Before I start, would you like to know about the updates to the charges in this?
I would.
For count 1, it'll be reduced to pointing or aiming a gun or pistol at someone. That's OCGA 16-11-102. And because of that, count 2 will be no pros.
Got it. So, Mr. Greenway, now I understand you're pleading to a misdemeanor. You were charged with 2 felonies. The state has agreed to reduce the first felony to a misdemeanor and dismiss the second felony. Is that your understanding?
Yes, sir.
Okay. All right. Let's keep going.
Mr. Greenway, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Linton Martavius Greenway.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you would normally take that you haven't been given this morning?
No.
How old are you and how far have you gone in school?
I'm 46 and I have associate degree.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Representing yourself, do I ask about the waiving the formal reading of the indictment?
Sure.
Okay.
You just don't say counselor. You say Mr. Greenway.
Mr. Greenway, do you waive the formal reading of the indictment in this case?
Yes.
Do you also waive any and all defense in the indictment for the purposes of this plea?
Yes.
Do you remember being arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Are you aware of any outstanding warrants?
No.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 12 months probation?
Yes.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today?
Yes.
Are you a United States citizen?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea today?
No.
And are you pleading guilty because you have decided that it is in your best interest to do so?
Yes. That's what's considered the Alfred plea.
Yes, sir.
Mm-hmm.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes.
As to indictment number 25 SC 001819, how do you plead to the reduced count of pointing or aiming a gun or pistol at someone as count one?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a direct right to appeal from your guilty plea, but if you believe that there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal?
Yes.
Do you understand that that procedure must be completed within 30 days from today?
Yes.
Do you understand that you have only 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
Thank you, Mr. Greenway. Your Honor, if this case were to proceed to trial, the state would show that on April 29th, 2023, officers of the Atlanta Police Department responded to a weapon call at 1134 Moreland Avenue Southeast. That's in Atlanta, Georgia, and also in Fulton County. When the officers got there, they spoke with the victim, Mr. Tony Williams, in this case, who stated that the defendant, Mr. Greenway, pointed a handgun at him prior to the officer's arrival. Mr. Greenway was still on the scene, sitting in his vehicle at this time, and the officers approached him to talk to him about the disturbance or the weapon call. Mr. Greenway matched the description of the person that the victim described as the person who pointed the gun at him. When they talked to Mr. Williams in this case, he stated that he asked the defendant or said something to the sort as, "I heard about your incident last night." And Mr. Greenway replied saying, "Mind your effing business." And at that point, that is when the victim stated Mr. Greenway pointed a gun at him. Mr. Williams stated that Mr. Greenway then left the location and returned when he saw the police there. Mr. Greenway gave the officers permission to search his vehicle. When the officers searched the vehicle, they found a handgun, a black and silver Taurus handgun with 9mm rounds. At that time, the defendant was taken into custody and charged with the charges that we have here today, or the act of assault and the possession of a firearm during. All this occurred in Fulton County, and those are the facts of the case. Regarding the negotiated plea between the state and the defendant in this case, the state is asking for a 12-month probation for count 1. And for special conditions of probation, we're asking for the defendant to complete an anger management course, 40 hours of community service, to stay away from the incident location. It's my understanding that it's like a liquor store or something, but to stay away from the incident location and to have no violent contact with the victim in this case. The state did get an opportunity to speak with the victim. He said since this has occurred, he saw the defendant out like in public and they squashed their beef. It's something where if they see each other now, they just dab each other up. He doesn't feel threatened or it's safety for his life if he sees Mr. Greenway. Also, Your Honor, when it comes to this reduction, it came after listening to the facts and circumstances of the case, how the victim felt, what he wanted out of the case, and kind of the I want to say inconsistencies regarding if Mr. Greenway pointed the gun or not, hence why he's taking it under the Alfred plea. But that is all from the state, Your Honor.
Got it. Thank you so much. Good morning, Ms. Stallworth. How are you?
My apologies. Good morning. How are you?
I'm doing all right. Can you share whatever criminal history information you have on Mr. Greenway?
Yes, Your Honor. Mr. Greenway has 4 cycles total and no felony convictions listed.
And what's the most recent cycle?
One moment.
Thank you. Perfect.
It would be. There was a UI in October of 2025 from the city of Atlanta. No disposition listed. It was a misdemeanor though.
Got it. Thank you.
You're welcome.
Mr. Greenway, tell me what you do for a living. You've probably told me before, but I
I'm
don't
a
remember.
surgical technologist.
Where do you do that?
At the Atlanta VA.
How long have you done that?
Since 05, close to 20 years.
Okay. And how do you know Mr. Williams?
I didn't know Mr. Williams before the incident.
It was just sort of happenstance that you guys were in the same place?
Well, I guess it was kind of like happenstance, but can I speak?
It's your turn.
The night before, I was actually shot at, and my windshield was shot out of my car.
Okay.
So the next morning,
near this liquor store?
Yeah.
Okay.
So the next morning, that was the reason for me having my handgun on me. I went to the store because I know the owner of the store to maybe look at the surveillance tape to see who did it so that possibly I could press charges.
Mm-hmm.
I encountered Mr. I don't even really know his name or whatsoever.
Okay, Mr. Williams.
As I was passing out of the store, and he did say something to me, and I just glanced at him and kept going. I got in my car before I could put my gun in the glove compartment and everything and get my watch. Whatever I was doing, police came out of nowhere. I never even knew Mr. Williams had anything to do with being a witness until I was locked up at pretrial at my bond hearing.
Okay. Have you seen Mr. Williams since you bonded out?
Yes.
In what capacity?
At the grocery store, because evidently we stay in the same area. This was in the area where we stay at. And I was in the grocery store and he approached me and introduced himself to me.
Okay. And you still live in that same area?
Yes.
All right. So you might encounter him again.
Mm-hmm.
Okay. All right. So you've been a surgical tech for a long time, steady job. You have decided to move forward without an attorney. Is that correct?
Mm-hmm.
And that's after a lot of thought and a lot of discussions that you and I have had.
Yes.
Okay. And you're comfortable continuing to do that?
Yes.
All right. You understand that you are entering an offered plea, which is, we also call it a best interest plea, where you say, I don't think it happened exactly the way the state says it happened, but I like this offer enough that I want to move forward. Is that a fair description?
Yes, it is.
Okay. You understand it's still going to show up on your criminal history as a misdemeanor, pointing a pistol at another.
That's fine.
What's the status of your DUI? I don't want you to tell me anything about the facts, just you got arrested not all that long ago for a DUI. Is it going to be a trial? Has it been dismissed?
I'm gonna take a plea deal in that case also.
You're working it out in state court?
Mm-hmm.
Okay. That'll be another misdemeanor.
Mm-hmm.
Yes? Okay. All right. Anything else you want to share with me about your life or this situation?
No, I just have one question.
What's that?
When would I be able to get my firearm back if possible?
Well, that's a good question because I was going to address that. Why are you so anxious to get it back?
No, because it's a nice gun and I actually paid a good little penny for it. And since I worked the deal to get it reduced, I knew if I would have been convicted of a felony or it didn't get dropped down, I know that was bye-bye to the weapon.
Right.
But since I worked the deal to where I don't have the felony anymore, just a question.
Got it. Okay. Once you get your final disposition, that's the paperwork indicating what your sentence is. You could, it sounds like this is Atlanta police. It should be an Atlanta police property somewhere. And so you would go saying, look, this was my arrest number or ticket number or whatever it was. And I'm trying to track down my firearm. You should release it. They may say, well, we need an order from the court or whatnot. I'm happy to assist you with that. But you'd want to start with the Atlanta police.
Okay.
And I don't mean to make it sound like it's a simple process. You may have to go from place to place to place, but if you're motivated enough, it ought to still be sitting in evidence. Okay?
Okay. And the only reason why I asked, because like I say, I don't have a firearm now because I knew there was a no-no under my bond conditions.
No, I appreciate
and I
that.
have a family at home and no protection. And like I say, this whole incident started with me being
shot at. Right.
Exactly.
Any idea why someone would shoot at you?
Yeah. I was actually sitting in the car about to leave, and some panhandlers walked up and was asking for spare change. And I never rolled down the window and waved them off. They went within an alleyway, and I found this out the morning when I went to look at the tape. And one of the guys gave the female the gun, and she shot at me. She actually shot at me twice.
Really?
The first time, I just thought it was random shooting. The second time, as I looked up, I could see the trajectory of the bullet coming. And if the caliber gun would have been big enough, I might have been sitting here today. It hit right where I was sitting at, and I had to duck, and it shattered my windshield.
Wow. Okay. So it was the panhandlers. All right. And you want a gun because you're going to shoot back at them?
No.
No.
No, I want a gun so I can protect myself.
Okay. All right. Those are fair questions, and I've given you what I can share, which is you start with the Atlanta police and say, look, my case is closed now. I'd like my property back, because that's what it is your property.
Mm-hmm.
If they say they need an order from the court, then you know how to find me.
Okay, no problem.
All right. Well, Mr. Greenway, I find there's a factual basis for your plea. I appreciate it's an offered plea. But if Mr. Williams came in here and testified one way, a jury could believe him. I don't know how that would play out. I understand why you want to put this behind you. I also find that your plea is knowing, meaning you've understood what we talked about, and voluntary. No one's forced you to enter this plea. Do you agree with that?
Yes.
Okay. Mr. Greenway, we now typically electronically sign the indictments rather than hand them around. Do you authorize someone in my office to electronically sign your name to the indictment indicating your offered plea to the misdemeanor that count one has been reduced to?
No problem.
No problem. Okay. Ms. Smith, can we sign for you? All right. Mr. Greenway, I will follow the negotiated resolution and sentence you to count one, which has been reduced to pointing a pistol at another, to 12 months probation. During those 12 months, you'll need to complete an anger management course, and probation can help you find that. You'll also need to complete 40 hours of community service and stay away from that address on Moreland Avenue. It's probably good for your safety if that's where you got shot at. And then no violent contact with Mr. Williams. You guys live in the same neighborhood. So if you see him, you can wave, do whatever, but don't point a gun at him.
I ain't gonna do nothing to him.
I don't think you will, but that's just, I understand why the state has asked for that to be a condition of your sentence.
Gotcha.
All right. And if you complete that anger management course and that community service promptly, you can ask misdemeanor probation to reach out to me about ending your probation early. If things are going smoothly and you've taken care of all those obligations, I'm open to an early termination. Okay?
Thanks a lot.
There is a form. You'll do that? Thank you so much. Ms. Simpson is with felony probation, so you're not going to have to mess with her. But she's going to give you a form that you do need to fill out with all the contact information so that misdemeanor probation can reach out to you. When they call you or do whatever they do, you need to respond. Because if they reach out to me saying, we can't find Greenway, I'm going to sign a warrant and you've turned everything upside down. Okay?
No problem.
So work with Ms. Simpson and filling that form out. Once that's been filled out, you are good to go.
Okay.
Any questions about anything?
No, but I just want to thank the court. And thanks to the DA, Ms. Smith, for working with me or whatsoever. And thanks for working with you because you seem pretty fair. I've seen you a lot on TV in bigger cases or whatsoever.
All right. Well, now you know in real life I'm fair, not just on TV.
And I just recently had twins about a year ago.
Well, congratulations.
So if I could have afforded a lawyer, I think I could have beat this.
You may well have, but I also understand why you made the decisions you did. And I'm excited for you. Boys, girls, one of each?
2 boys.
2 boys. So how many other kids in the household?
No more in the household. I actually have a sophomore in college, a senior in high school, and a sophomore in high school. I'm too old to do that again.
You're in the medical profession. You should know how, like, babies don't fall from the sky.
Oh, I know it, but
yeah, twins. Whew. Well, congratulations. You've reset the parental clock by 18 years.
Who you telling?
Well, I'm telling you and their mother. Good luck with all that. Okay. Meet with Ms. Simpson and then you're good to go.
Okay.
All right. Thank you, Ms. Smith.
Thank y'all. Thank y'all.
It's TCF Live on a Tuesday as we're about to enter hour 3 of the show, brought to you from the great Sonoran Desert. I hope you're all having a good day today. Let's go back up to Michigan. Judge Middleton. Well, Judge Middleton studies his materials. Barbara, thank you for the $5 earlier. I appreciate it.
Are you Kyle Everett Singler? Yes. And I learned from the arraignments that you and Anthony Grant are father and son and connected in this case. We've continued Mr. Grant's case to a pre-exam next Tuesday, which would shift it to Judge Patterson's week. Are we asking to adjourn this matter to the same date?
Yes, Your Honor. I have received an offer from the prosecutor's office of attempted instruction from the police officer. I have been indicated by Attorney Mabry that will remain open until the next probable cause.
All right, let's pre-exam for April 28th at 8:30. And a prelim if needed for May 5th at 1. I'm not worried about either one of you keeping in contact with your counsel. You both are on the same page. This matter will be continued to next Tuesday morning at 8:30. Stay in contact with your individual attorneys, and Judge Patterson will be handling this case unless it somehow gets shifted back to me. But you're both good to go. Mr. Singler, your bond is continued. See if you owe me any money. It doesn't appear you have any unpaid fines or costs to the court. Mr. Singler, you're good to go. All right, we're going to get to the point where we're going to need some help from Mr. Gabriel. I've got a couple questions. Well, we'll see. Is James Anthony here?
He's not present. I've called the hall multiple times. It's been a couple minutes since I've called the hall.
Well, he's failed to appear for his pretrial services also.
I've had no contact with him.
Is Justin Spence here?
Yes.
He also is subject to a bench. All right, well, let's make a record on James Anthony. This is file 26609 FY. Mr. Anthony is charged with possession of methamphetamine alleged to have occurred on April 4th. He posted a cash or surety bond of $15,000, promptly failed to appear for pretrial services, and never contacted his lawyer, and he isn't here today. So I'm going to do a bench warrant. Notice of bond forfeiture. New bond. $20,000 cash or surety. A 48-hour hold. Also asked $280 worth of unpaid fines and costs. In the old days, when they would contact the bonding company, they would actually go out and find them. I don't think that happens anymore. But he's subject to forfeiting a $15,000 surety bond. Maybe that'll get his attention. Anyway, I'm disappointed that he is not here. Casey, let me go through these in alphabetical order and see where we are here. I have a waiver in Aiken. Michael Ashbrook. I'm just checking in right now, so he's here.
The waiver on this file, prosecutor has countersigned that waiver.
All right, Mr. Ashbrook, would you come forward? Mr. Ashbrook, this is file number 26645 FY. You're charged with carrying concealed weapon and no valid operator's license. Oh, wait a minute, wrong guy. Don't want to scare you. You're charged with carrying concealed weapon. It's alleged that on January 10th in the village of White Pigeon, you had a machete. They're going to bind this over for the waiver? All right,
Prosecutor is
all right,
not resolving it with a misdemeanor at this time.
okay. The reason I wanted to talk to you, Mr. Ashbrook, is you've got $1,330 worth of unpaid fines and costs. Back to 23, no proof of registration, speeding, impeding traffic, no insurance, plate violation, no proof of insurance, open intox, and a registration plate violation. Most of those are misdemeanors. I can wipe those out with a jail sentence. Would you like me to just put you in jail and wipe out your fines? All right, apparently your next payment is due May 20th, so you're on a payment plan for those and you're making your payments. All right, very good. I talked to you about that at your arraignment. It's a lot of money, but if we keep chipping away at it. All right, Mr. Ashbrook, you're good to go. Danny Flowers?
Getting Flowers is going to be obtained. I have a signed paper of right to be form here. Do you want to take care of him now, or do you want to wait for Attorney Gately?
Well, let's see. Oh, just quickly have a seat back, Mr. Flowers. Come back to you in a minute. Caden Jesse.
He's going to be a preliminary examination.
All right.
Not in the right order.
Sure.
Tuesday afternoon.
And that's it.
He's gonna check.
Okay.
Bring a snack, bring a book. It's gonna be a minute.
Is that for 28?
And I give you another notice.
Are you Caden Jesse Gose? Mr. Gose, the allegation is that you were in an automobile accident on Nottawa Road on January 19th of December 19th of 2025. And you were intoxicated. You caused a serious injury to Becca Mead. That is a felony. It's punishable by up to 5 years in prison and a fine of up to $5,000. It also is alleged that you were in an accident at Nottawa and Bojan Road, and you failed to stop at the scene of that person injury accident. That's also a misdemeanor. And also is alleged you didn't have a valid license. When you're charged with such an offense, it is a felony, and you're entitled to have what's called a preliminary examination, where the prosecution must establish that there's probable cause to believe that a crime was committed, probable cause that you did it. The date alleged was December. Let's see what's in the complaint. December 19th. Someone else was in the car and you took off. And, they got you later at the hospital and took your blood alcohol. All right. Is there a plea offer in this case?
The plea offer was to count 1, the felony operating causing the operating while intoxicated causing serious injury, with a dismissal of the failed to stop at a scene and operating no license.
All right, I'm going to set this for prelim for April 28th. At 1 o'clock. Let's see how bad that day looks.
Your Honor, we might want to bring a snack.
Okay, I do get hungry.
It'll be a long afternoon.
Oh. Yeah, everything from today is theoretically set for next week, and this could be a lengthy prelim. This also allows the prosecutor to use the laboratory reports at a preliminary examination as opposed to calling the doctor or technicians in, and they filed a notice to do that. Mr. Gose, are you still at Green Lawn in Sturgis?
Yes.
How'd you get here today?
I ended up getting a ride from the owner of that property, my grandma.
All right, so are they here now?
Oh, yeah.
All right, very good. You have been in contact with the community corrections people? Are you on pretrial services with community corrections?
No, I don't think so. I'm not sure.
I wanted to provide an update that
Yes,
Mr.
he
Gose
is.
has contacted our office and completed enrollment as part of his bond conditions. So are you on board with that or not?
Yeah.
All right. Okay, well, prelim next Tuesday at 1 o'clock. Let's see if you will want to hear. You got a disturbing the peace ticket of $250 from December of 2025. Have you done anything on that?
I haven't, no.
Are you working someplace?
No, I lost my social security, birth certificate, NID, and the wreck. It was all in the car.
Well, this accident occurred on December 19th. I'm
And I
not sure
just-
what the date of that disturbing the peace was, but I want you to start to pay on that. I can just put you in jail and pay the fine that way. So I want you to make some payment between now and next Tuesday, all right?
Okay, I got you.
All right, you're good to go.
Send me an email. I'll see you next Tuesday.
Bring a snack, huh?
Mhm.
All right, friends, let's change it up a little bit. I'm going to take us to Judge Oakley's court. So they're going to do what looks like a prelim exam. The defendant appears to be pro se. There was some lead into this earlier that I'm going to skip over because there was a lot of gaps in it, but the long and the short, it sounds like they had some dispute over discovery, but it seems like that was solved. So anyways, Judge Oakley, and it looks like we're going to do a prelim exam.
I've yet to find anything that works on this one. Are we ready? Okay. All right, let's call a witness.
Michael Pearl.
Officer, come on up. Raise your right hand for me. Swear or affirm, tell the truth, the whole truth, nothing but the truth. Watch your step on the ramp. Have a seat in that chair. When you get over there, hand me that box of Kleenexes. Sure. I don't expect you to get a little weepy today. Thank you. Yep.
Yeah, Your Honor.
Yes, please.
Hey, Your Honor. Morning, Officer Pearl.
Morning.
Sir, how many years have you worked as a police officer?
About 6 years.
Taking you back to June 22nd, 2024, at about 11:20 at night. Were you working?
Yes.
What were your responsibilities, Officer Pearl, on that evening?
Respond calls and perform my regular duties.
Were you in a vehicle or were you stationary?
I was in the vehicle.
Marked and unmarked vehicle? Were you in uniform or plain clothes? Officer Pearl, on June 22nd, 2024, did you meet a gentleman named Nathaniel Bradford?
Yes.
Is this on the record example? If you want to vote, hopefully you know what we speak. Let's see where.
Green.
Your Honor, may the
Sure.
record reflect the witnesses identified the defendant, Mr. Bradford.
Noted for the record. Are you referring to the?
Well, you said you met a man in this.
Okay, yes.
So what caused you to interact with him or notice him?
I attempted to pull him over. I'm traffic stop.
In the vehicle or was he walking?
Using the vehicles.
You remember the vehicle?
Yes.
What model?
It was a Chrysler Common Country.
You remember the color?
Purple in color.
Was he alone or did he have an occupant with him in the vehicle?
He had a single pass.
Was Mr. Bradford driving or was he the passenger?
He was driving.
What did you notice about his driving?
I noticed that he disobeyed a stop sign and failed to signal his turn
On what street did that occur?
at the intersection of Belleville Boulevard and Sumter Road.
In what community?
The city of Belleville.
What else did you notice about Mr. Bradford's driving?
I observed that after I had activated my overhead lights, his speed increased significantly.
What does that mean he was a police officer?
He was attempting to flee or elude me.
Officer Pearl, when you first noticed the defendant and he disregarded the stop sign, were you next to him, behind him, or in front of him? In front of his vehicle.
I was, he was coming at me, so we were, he was the front.
Where was your vehicle when Mr. Bradford began to drive at a higher rate of speed?
I'd say in the area of Sumter Road and Owen by 600 Sumter.
Your Honor, I would like to address the court and say that request earlier to increase the charge, the defendant has enough pain later on that to seek that increase.
Thank you.
Thank
No problem.
Officer Pearl, when if at all did you attempt to make a traffic stop? At what point?
I was passing the Belleville Plaza where Dollar Tree is on Sumter Road.
Can you estimate for his honor the amount of time or the distance you spent pursuing this offense?
About 3/4 of a mile.
What part of, did you have overhead lights and siren?
Yes.
Did you activate either or both or none of those items?
Both.
Were they functioning?
Yes.
Did Mr. Bradford heed your request to pull the over?
No.
You remember the time this occurred?
This was just before midnight, I believe.
Officer Pearl, did you form an opinion one way or the other whether the defendant knew you were trying to pull him over?
Yes.
What's the basis for having an opinion? What is your?
Can you rephrase this question, please?
Sure. And you activated your overhead lights.
Yes.
And you said you didn't stop doing it.
Correct.
So about a mile.
Yes.
And you increased speed.
Yes.
Did you form an opinion whether he knew you were there trying to pull him over?
Yes. My opinion was he was actively trying to flee.
Sir, ultimately,
Did you stop him?
Yes.
And when you stopped him, did you make any observations about his state of sobriety?
Yes.
What did you do which enabled you to detect and notice his state of sobriety?
As Mr. Bradford was exiting his vehicle, a partially full can of Corona beer fell out of his lap. As he was being taken into custody, I observed him having bloodshot, watery eyes, slurred speech, and he admitted an odor of intoxicants from his breath was stolen.
Did you inquire of him whether he had consumed any alcohol that late afternoon or evening?
I don't remember if we inquired on his alcohol intake that night.
Tell the judge the status of Mr. Bradford's driver's license on it.
Revoked.
How do you know that?
His return and leave is.
Without telling us the results, did you perform a PBT?
No.
Did you make any efforts to gain any blood or breath from him for analysis?
I asked him if he would be willing to submit to a chemical blood test.
What did he say?
He refused.
Well, did he submit eventually to a chemical blood test?
Yes, we had to get a search warrant.
Did you gain a search warrant?
Yes.
Do you remember from which jurors he was commuted? Remember the judge?
I don't remember the exact judge, I'm sorry.
Are you with the one the blood was extracted?
Yes.
Where does that take place?
Orwell, Canton.
Do you remember who extracted the blood or what type of position that person had?
I don't remember her name, but I know she was a registered nurse. I think her last name sort of. Like that.
Now, what if anything did you notice about the defendant's breath?
It smelled like intoxicants.
Your Honor, at this point, I would move to admit proposal to the board if I may approach. I've shown a copy to the defendant.
Thank you.
Your Honor, what I've just tendered to the judge is the lab report issued on July 10 of 2024. Michigan State Police, its laboratory number from me, 2X24 9569. And the result of this blood analysis, according to Michigan State Police, Leland Diane Bennett, forensic scientist, the defendant had blood alcohol level of 0.150. So with that, Your Honor, no further comment.
Are you moving for this to be admitted?
Yes.
Mr. Bradford, any objection to exhibit number 1 being admitted into evidence? Thank you.
Thank you.
Oh, you've already got a mark. Mr. Bradford, do you have any questions for Officer Pearl, sir?
Yes.
Okay. You can stay right there or you can come up at the podium, either one.
You say in the report that you were posting in front of the vehicle down some road. You initiated lights.
No, I initiated my lights, after you passed me, I had to turn around. So I was behind you when I initiated my emergency lights.
So then how far was it between the place where you had the U-turn?
Yeah.
How far was that between the time you took made the U-turn?
It was fairly quick. I turned around and I exited my lights shortly thereafter.
So you said the car was speeding already, or was it fleeing from once?
No, your speed didn't increase until I turned on my lights.
Well, the question was the car already speeding, or
No.
you think that the car was speeding or already fleeing before it stopped?
Let me stop you because I'm confused by the question. I think what you're asking him is, did he think you were traveling over the speed limit before he got behind you? Is that what you're asking him?
Far as the fleeing and eluding.
No. Just, is that the question you want to know? Did he think you were speeding while you were still approaching each other? Is that the question? At that point, while you're still approaching? Okay, you understand that question?
I don't believe you were, no. Technically, you can't
even be fleeing if my lights aren't activated. So,
That answer the question? Okay, any other questions?
yes, one other. So after you stop the car, you didn't have footage on your camera. Stop. I have footage of the entire incident, yes. Yes.
Any other questions? Okay, any follow-up?
Yes.
Yeah, go ahead.
You mentioned to the judge about the stop sign violation. Did the defendant commit any other civil infractions in your presence?
He failed to use his turning signal when he was turning on the Sumter Road from Balboa Boulevard.
Lastly, can you tell the judge the speed limit of the beginning area, beginning time when defendant fled to when you finally pulled him over? You know what the speed was?
So when he initially started fleeing, the speed limit was 40 miles an hour, and he was traveling upwards of 68 miles an hour. And when we
Was
crossed,
the speed limit ever diminished before he was finally pulled over?
yes,
What's the speed limit in that area where you finally pulled him over?
in the area from the train tracks to where he eventually stopped his vehicle, it's 30 miles an hour.
Thank you so much. Nothing further, Judge.
Any follow-up questions? Yeah, go ahead.
So, the road you said was Belleville Boulevard? Yeah. How far is that from the stop? How far is that from when we took the route?
Let me stop, because once again, I want to clean up your question. I think what you're asking is from where you pulled out onto Sumter Road to when he did the U-turn, how far is that?
Yes.
Okay, one at a time. Okay, approximately how far between Bellevilla, Sumter intersection and where you did your U-turn?
Less than a quarter mile.
Okay, now the follow-up question would be,
Stop for all of that. Yeah, I didn't observe. I did not observe you use a turn. So.
no, I don't think, he said, I did not see you use a turn signal.
Oh, that's all.
Your question is, could he see that distance?
Yeah, I could see the lack of the turn signal use, yes.
That's it? All right, Officer Pro, you can step down. Watch your, thank you. Watch your step on the ramp. All right. Okay. Are we ready for argument? Go ahead.
In this case, we have proven to you that the defendant drove with an unlawful blood alcohol. We've also proven to you that he was driving while under the influence based on the observations made by the officer. You're under the speed limit in part of the area where defendant was fleeing is 35 or less. So that would enable us, if it's 4th degree fleeing, to be 3rd degree fleeing. It also becomes 3rd degree fleeing because defendant's a crime of conviction for fleeing and eluding, which is part of the packet. We believe probable cause has been established that the defendant committed count 1, Your Honor, fleeing and eluding 3rd degree, count 2, OWI 3rd, piggyback 1, 2, 7. We respectfully would seek a fine over judge on the 3 counts.
All right, Mr. Bradford, any argument?
Keep us just looking at this. It's slurry mechanisms. Not very fulfilling time. Wish I had more before.
Okay, well, you'll probably have more before it's time for trial if that's where this is headed. But my question is, do you have any argument to the bind over in response to the argument Mr. Kaplan just made?
Yes, that's what preliminary exam.
I'm sorry, say what? This is a preliminary examination. Yeah, this is the probable cause hearing today. What we just did was a preliminary exam.
Sorry about that. I'll see that it proved that this was fine, this was legal. Well, see my name's not. Sorry, I'm not gonna do it. And it's still footage of we drive on me.
Okay, anything else? Okay, so as far as identification, the officer's testimony is enough for probable cause to establish your ID. So I'm gonna bind you over on counts 1, 2, and 3. We'll send you downtown for the next step of the proceedings. The next date is the arraignment on information, which will be next Tuesday at 9 o'clock at the circuit court level. Do you have any questions about that process? All right, I'll continue your bond. Anything else?
No, thank you.
Mr. Bradford, please listen to me. Do yourself a favor, take advantage of the court-appointed attorneys. Dude, I mean, you did a decent job with your questions today, but you're so far over your head on this thing. All right? I tell people all the time, I don't care if you're the smartest guy in the room right now. You still don't have the training and the experience to represent yourself. I know real good attorneys that don't represent themselves when they have problems. Take advantage of the attorneys. Do yourself a favor. I'll sleep tonight. Good luck downtown. Thank you, gentlemen. Be safe, officer.
Yeah, I wholeheartedly agree with Judge there. He's over his skis. He needs help. So hopefully he does that. Programming note for tomorrow's pre-show. So that's for members. If you're not a member, consider changing that right now. It's only $2.99 a month, and the pre-show is always worth it. Just ask the members. But I'm going to share some things that I've found regarding that historic courthouse in St. Joseph County where Judge Middleton is currently sitting. Because I've found some fun photos and some fun facts and all of that, and I will share that in tomorrow morning's pre-show. Let's check back in on Judge Glazer. It's coming up on lunchtime. Let's see how she's holding up.
Or do bodily harm.
Okay.
I do not see any criminal history.
Victim says he does not know Mr. Rodriguez, but he knows a female that's friends with him. But he doesn't know he got his address. He had a dispute the night before with the female that she sent him to fight. Okay, I think you're right. It's probably best, more accurate charge would be written threats to kill or do bodily injury. You are ordered to stay away from Maxwell Dorsett, the alleged victim. No contact with the victim either directly, indirectly, in person, in writing, by telephone or through third parties. And you must stay at least 500 feet away from the victim, his home and school and place of employment at all times. And stay away from the victim's residence at 1240 Southeast 31st Court in Homestead, Florida.
Yes, ma'am.
You understand that? Stay away, sir.
Yes, ma'am.
Thank you. Say, what do you want for bond?
2,500.
It's a second degree felony.
So then 5,000.
5,000.
Okay.
So I'll set your bond at $5,000. Good day, sir. So we finished our morning calendar. Would you like to start at 1:20 or 1:30? It doesn't matter to me.
1:30 is good, Judge.
1:30? Okay, we'll see everybody at 1:30. Enjoy your lunch.
She got done a little bit early. You go, Judge Glazer. You know, it's a weird day out in Courtlandia. There's a lot going on and very little going on all at once, if that makes any sense to you. It's just weird. But let's head back to Judge Middleton. He's the best show at the moment.
We're fine. We've been working through the cases that we didn't need you on, the waivers and that sort of thing, but we're getting down to crunching here. Stephanie Smith.
Stephanie Smith will be at plea. She is present.
Justin Spence, you mentioned, is present.
He will be at plea and he is present.
And he has failed to contact community corrections. Will we rectify that?
He indicated to me during our last phone call that he did contact community corrections. He's here today to enter a misdemeanor plea.
All right, James Swinehart.
James Swinehart, I spoke with him at the jail on Sunday. I did not have offers at that time. At this time, I am still missing reports in file 252671FY. And as I said, I've not had an opportunity to consult with him. For this one, I would ask that this be adjourned to the next PCC date so I can discuss this matter with him.
Any objection to that, Mr. Gabriel?
No, Your Honor, there's actually 4 files with Mr. Swinehart. Trying to get a handle on all of those different cases probably will take us a little time.
I'm dumping a lot of these onto Judge P, which I don't really like doing, but Casey's here that day and it's going to be as bad a day as this is. Continue that 1 week. Pre-exam is set for 4/28/26 at 8:30. Preliminary examination, if needed, will be May 5th, 26 at 1. There are substantial bonds in each case, so Mr. Swinehart isn't going anywhere. He also has $458 of other unpaid fine costs. All right, now it looks like we've got several pleas to take, and then we'll see what we're gonna do with our in custody folks. I wish I could get this chair fixed. We all bent over. Let's start with Mr. Rhodes. Would you come back up and have a seat next to your lawyer?
Thank you.
Byron Arnell Rhodes.
Yes, sir.
We've met. You're charged here with possession of cocaine as a second offender, making that punishable potentially by up to 6 years imprisonment. If I understand correctly, Prosecutor Gabriel's agreed to reduce this to a misdemeanor charge of use of cocaine with potential 7411 status for sentence. Is that correct, Mr. Gabriel?
It is, Your Honor.
Seventy-four eleven is a section under the Public Health Code 333.741, which allows the judge to put a person on probation on a controlled substance charge. And if you complete the terms of the probation, the charge could be taken off your record as a public record of conviction. So that's a benefit. I can do that one without the prosecutor's consent, as opposed to some others, but I generally wouldn't if they objected. Cocaine had disappeared for a while. When I first started, our drug was heroin, old-fashioned powdered heroin and tar heroin. Then cocaine hit, and we thought we were overwhelmed. Then crack cocaine hit, then we were really overwhelmed. But then we had opioids and methamphetamine, and cocaine kind of faded into the background. Mr. Rhodes, have you had any previous drug convictions in any other jurisdiction?
Never.
Are you on probation or parole?
I'm on bond.
On this case?
C. Yes.
Well, everybody here is on bond, so that's all right.
Okay.
You're on a payment plan on a driving case that we dealt with a while ago, and you got a bunch of unpaid booking fees, but I'm not chasing those anymore. You had a bunch of stuff when you and I were both younger, which has mostly been taken off your record. Yeah, there's a lot of baggage in here. I think if I do take this plea, which I plan to, I'm gonna set it for sentencing to get some more information before I do the sentence. Mr. Rhodes, are you gonna plead to the charge of use of cocaine, which is a misdemeanor punishable by up to a year in jail and a fine of up to $2,000? Use of cocaine?
Yeah.
It's a misdemeanor.
Yes, sir.
Anybody threaten you to get you to do that?
My lawyer.
All right, she threatened you to get you to.
We can't mess around about that, okay?
This is serious business. I had one guy say, yeah, my wife told me she'd kill me if I didn't plead to this. But I mean, if your lawyer, the prosecutor, or probation officer, the judge, anybody threatens you to get you to try to plead to this?
No.
Or promise you anything? Other than the plea offer?
Yeah.
All right, you understand that if you do plead to this, you're giving up all these rights on the advice of rights?
Yeah.
Well, let's talk about this case. According to the affidavit, There was something going down at North Main Shell. And they found a baggie with some drugs in it. And you'd been in there sometime earlier and apparently dropped that baggie. And then they watched the video and realized it was you. So had you had a baggie of cocaine that you accidentally dropped at the Shell store?
Yeah.
And had you used some of that?
One more time?
Had you used some cocaine?
Not at the time.
All right, well, had you used some like within?
In my life, yeah.
All right, but
And Your Honor, we're doing the plea to
Based
the
on-
possession of cocaine as the lesser included being use. He's not admitting to using it actively, just having knowledge and possession of it.
is that correct?
Yes, sir.
Yes, Your Honor. Oh, I'm sorry.
So everybody agrees.
We're all in agreement.
Well, if they gave you a test right now, what would that show?
A lot of marijuana.
Well, marijuana is lawful for adults to use for recreational purposes. If I put you on this probation or 7411, you're gonna be able to smoke weed, you
I know
understand?
that. I
You
know
willing to do that?
Yes, sir.
All right. I'm gonna set this out a little bit.
This is on. Okay, so next week. Today, this is canceled. He's gonna get a sentencing date. We'll leave for sentencing date.
We try to use Wednesdays for Ms. Strong. Are you available Wednesday, May 27th?
I believe so, Your Honor. Let me double check. Yes, I am.
At 11 a.m. Oops, at 10:30. I'm gonna ask you some questions. I'm gonna ask you, where'd you get it? Whose baggie was this? And I want you to pay on your other stuff. And then we'll figure out what we're gonna do, but we'll probably do a drug test that day. I don't expect you to be at zero, because you probably can't get to zero by then, but there's a time of probation, you can't use any marijuana. Are you working somewhere?
Yes, sir.
You told me that before, but I forgot where.
Pittsburgh at Summit.
Yeah. What shift?
Third.
So you've been up all night?
I didn't,
Did you work last night?
no,
Okay.
no. I got off. My supervisor, he just let me get some time off.
And Your Honor, I am owed to Judge Pattison at 11 o'clock. Can I ask one of the deputies to give him a note that I might be a moment late?
Don't say a little late, say she may be late.
A moment late.
Um,
Thank you, guys.
Pregnant moment late.
I sent an email and I just want to confirm.
That would be Wednesday, May 27th, 2026 at 10. There's courtroom C. I guess this is courtroom C. I'm not sure what it is, but that's what we call it. C is the courtroom. All right, Mr. Rose, I will see you on May 27th. Don't get any more trouble. Get your stuff paid off and we'll talk about this probation at that time. Yeah.
You can check with the clerks.
You had allowing another to violate the motor vehicle code set for 331. I'll give you that. I don't think so. I think you got one left. Mhm. All right, go ahead. Yeah, okay. Now,
So I think the word they were looking for there to describe how late she will be is a skosh. I think she'll be a skosh late. Anywho, good morning once again, everybody. TCF Live. It's Tuesday, a little over an hour left to go. Let's go. Hold on, Great Granny. Great Granny says you're in courtroom 3B, judge, not C. No, 3B refers to the actual district court. It is district court 3B, not the room. So that's what that refers to on the Chiron. Anywho, let's go to Georgia. We'll check back in with Judge McBurney.
For part of this. Please to hear you.
You guys ready?
Yes, sir.
Great. All right. Can you slide that way a little bit? Excellent. So the court reporter can see and hear you. This is 25 SC 007022, State versus Juanita Callaway. Ms. Callaway is represented by Ms. Cabrera here in court, and Ms. Boykin represents the state. Ms. Boykin is about to put you under oath, Ms. Callaway. Once you're under oath, you'll need to answer all her questions truthfully and completely. Please let me or Ms. Cabrera know if at any point you've got a question. Will you do that?
Yes.
Okay, Ms. Boykin?
Ms. Callaway, please raise your right hand. Do you swear or affirm the testimony that you give in this matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your correct and true and legal name.
Juanita K Callaway.
Are you known by any other names?
No.
Are you under the influence of any alcohol, drugs, or medicine?
No.
I'm sorry?
No.
Okay. How old are you?
49.
And how far have you gone in school?
I got a certificate in practical nursing.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you're charged with 4 counts of conspiracy to commit a felony and 4 counts of possession or procurement of prohibited items, providing prohibitive items to an inmate?
Hold on one sec. Hey, Deputy Gordon, do you mind taking folks into the vestibule? We sit with very soft-spoken Ms. Callaway.
I'm just sick. I'm ready.
That's okay.
I'm sorry.
You happen to also be soft-spoken, right? It's not a critique. We need to be able to hear you.
Yeah. Yeah. Yes.
Okay. And do you understand that you have the right to either plead guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent, you may receive a jury trial?
Yes.
Okay. And have you gone over this indictment and its charges with your attorney?
Yes.
Have you had time to speak with your lawyer, Ms. Cabrera, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss this case with your attorney?
No.
Are you satisfied with her services?
Yes.
Ms. Cabrera, do you waive formal reading of the indictment?
Go away.
Do you waive any and all defects in the indictment, including with respect to your client's name?
Yes. I do.
Ms. Callaway, has your attorney advised you of the minimum and maximum sentence for each charge you're pleading to?
Yes.
Do you understand that neither the court nor the district attorney's office has anything to do with parole or Department of Corrections or Board of Pardons and Paroles, and no one can guarantee any type of parole or parole in this matter?
Yes.
Do you understand that this is a negotiated plea of guilty, which means that the joint recommendation of the state and defense to the court will be a sentence of 1 year probation on conspiracy to commit a felony, count 1. Counts 2 through 8 will be non-prossed by the state as it relates to you. That the conditions of probation is that you get evaluated, seek mental health treatment, that you not work in a jail or correctional facility, and that you have no contact with co-defendants in this case.
Yes.
Do you understand that the court does not have to accept that recommendation? The court can sentence you to the maximum on each charge and can run those sentences consecutively, one after another.
Yes.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea, you have the right to withdraw your plea of guilty?
Yes.
Do you understand that by pleading guilty, you give up the following rights? The right to remain silent and not incriminate yourself,
Yes.
the right to confront witnesses against you,
Yes.
the right to the assistance of counsel hired by you or court-appointed counsel if you cannot afford an attorney at the trial of your case,
Yes.
the right to the presumption of innocence,
Yes.
the right to testify on your own behalf and to present other evidence,
Yes.
the right to subpoena witnesses and compel the production of evidence,
Yes.
the right to have the charges against you proved beyond a reasonable doubt,
Yes.
and the right to appeal if convicted of these charges at trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Ms. Callaway, are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, please.
Have you ever pleaded guilty or nolo contendere or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No.
Has your lawyer explained to you the First Offender Act and conditional discharge statute to you?
Yes.
Do you understand that if you violate the terms of your first offender conditional discharge sentence or commit a new offense while on probation, your first offender conditional discharge status could be revoked? You could be adjudicated guilty and you could be resentenced up to the maximum sentence for each charge in the indictment.
Yes.
And do you understand that if you successfully complete your probation under the First Offender Act and are discharged, you can honestly say that you have never been convicted of a felony?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of a guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, and transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, that you could be found guilty of a felony?
Yes.
With respect to, this indictment, how do you plead to one count of conspiracy to commit fraud? Commit a felony?
Oh, guilty.
Okay. And I apologize, I lost the last page of my plea colloquy, so I wanted to make sure I didn't
Uh-oh.
forget to go over something. Are you pleading guilty to this charge because you are in fact guilty?
Yes.
Do you understand that you have 4 years from today's date for a felony to challenge the voluntariness of this plea through a habeas petition?
Yes.
I think I went over everything. Your Honor, should this case go to trial, the factual basis for the state would be that on June 27th of 2024, Lieutenant Battle with the Fulton County Sheriff's Department initiated, as a part of the Jail Investigations Unit, started an investigation based on a seized cell phone from inmate Reginald Arnold. Throughout the course of their investigation, they learned that the defendant in this case, Juanita Callaway, who was also working as a nurse through NAFCare, which is the assigned provider within the jail had begun a relationship with the defendant, Reginald Arnold, while he was an inmate at the Fulton County Jail. Throughout the course of the investigation by the Jail Investigations Unit, they were able to pull the phone calls between the defendant and Mr. Arnold, where it was clear during those calls that they had engaged in a relationship and talked multiple times. There were also text messages found on the phone seized from Mr. Arnold, where they discussed the bringing in of contraband, specifically a phone in the Fulton County Jail. Throughout those text messages, Ms. Callaway acknowledged that she had two phones brought in for the defendant. On the jail calls, which were recorded, you could hear them discussing the activation of the phone, her providing him with the password for or the SIM code in order to activate the phone while he was still within the Fulton County Jail. Your Honor, obviously the defendant has been charged with a significant number of counts, and the state felt pretty confident that we could prove this case going to trial. But some of the things that factored into the decision to reduce and non-press some of the charges is that Ms. Callaway took responsibility fairly quickly when she was interviewed by the jail investigation staff. Also, Your Honor, we would note that she did spend almost a year incarcerated at Fulton County Jail prior to indictment.
Yeah, I have 428 days, more than a year.
More than a year. There are also some additional extenuating circumstances that I'll allow her counsel to relay to the court.
Okay. Tell me Ms. Heath's alleged connection. I understand Mr. Arnold's connection now.
The detention officer at the jail and assisted, there's some text messages that implicate her in bringing the phone she had seen on some surveillance footage, carrying bags back and forth.
So she would know Ms. Callaway, or she was just a separate channel into Mr. Arnold?
We believe that there's a connection, but I think that it's also possible that they were not connected and they were working
Independently?
Independently.
Got it. Okay. And is Ms. Callaway, is any part of her resolution here an agreement to provide truthful testimony?
Not at this time, Your Honor. We don't think it's necessary.
Okay, got it. Ms. Stallworth, do you have any criminal history information on Ms. Callaway?
There's no prior history, Your Honor.
Thank you. All right, Ms. Cabrera.
Yes, Your Honor. Ms. Callaway, she did accept responsibility almost immediately. She is eligible for first offender, so of course we're asking for first offender. She is licensed as a nurse, and throughout this process, obviously, she can't work as one. She can get through the interviews, but she can't get any further. Unfortunately, in January of this year, her daughter passed away, leaving behind what was then a 4-month-old. That child is now in DFAC's custody, and Ms. Callaway is the only one here in Georgia, but she cannot take the child because this case is pending, and so DFAC's will not give her the child. Family would otherwise be in Florida. So one of the things is she's hoping that she can actually return to Florida at some point. There's concerns about some probation fees. She's working full-time right now. She's working for Publix, so she's working overnight. I spoke with the state about possible early termination of probation upon completion of any of the conditions that she has. And I would also be asking, Your Honor, if you would consider allowing this to be filed under seal, so that she can actually take up a job as a nurse without having this pop up on her.
Okay, got it. Ms.
Oh, I'm sorry, Your Honor. Just other small things. While she was in custody, it was like 14 months that she was in there. She was a chair for the New Beginnings program. So she was actively engaged in things that were positive while she was in custody, I guess making the best of that situation that she could. Hopefully you believe that the resolution we reach is appropriate, but go ahead.
Was the bond just too high? Why so long? It's just a bond you couldn't make?
Yeah.
Okay.
Yeah, I'm sorry. Yes.
And then did you eventually make it, or did the bond get lowered, or both?
The bond got lowered.
Until you could make it?
Yes.
Okay, all right. And you have a granddaughter now who is in DFAC's custody,
Yes. In Cherokee County.
and you would like to get custody of her?
Try to, yes.
Try to, sure. And if you did, and you managed to wrap up probation, your goal is to go back to Florida?
That's where all my family is. So I was only here with my daughter, and my daughter did not want to go back to Florida.
Got it.
So that's where all my family is. That's where I would get the help.
It would be natural for you to go back to Florida.
Yes.
You'd have support as you tried to raise your granddaughter.
Yes, yes.
Okay, that all
But
makes
to be
sense.
fair too is my family in Florida is trying to get my granddaughter too. So
Okay, got it. All right. Do you have any questions about anything we've discussed?
no.
Anything you want to add?
I just want to say that, although this was a very negative experience, for me, it was positive too, because it kind of changed me to be a better person. So although it was a long time, it was the right amount of time for me to mold myself to be better.
Give me an example of a way in which you're a better person now.
I was a little impatient before.
Okay, you're more patient now?
Yes, I didn't really have humility, so.
Okay, 428 days in the county jail will do that to someone, make them patient
Yes.
and humble.
Yes.
Okay, well, I hope you maintain those attributes as you move forward. Ms. Callaway, I find there is a factual basis for your plea. It sounds like the state's case was particularly strong. I could see why you wouldn't want to go to trial. I don't know that that would have turned out real well for you, but that's not really what this case is about anyway. It's about you taking ownership and not repeating something like that again. And it sounds like you've learned some important lessons and you have an important role to play going forward in your granddaughter's life. I also find that your plea is knowing and voluntary, meaning you've understood what we talked about and no one's forcing you to enter this plea, but you're doing so after consultation with your lawyer. Is that a fair statement?
Yes.
Ms. Cabrera, can someone in my office sign the indictment for you?
Yes.
Ms. Boykin?
Yes, Your Honor.
And Ms. Callaway, is it okay if we sign your name? And so we're clear that there are a bunch of counts in the indictment. You're pleading guilty to count 3. That's the first count that names you, but in the indictment is count 3. That's the conspiracy count. And then counts 4 through 10 are being null prossed. Those are the other counts that name you. Okay?
Yes.
Doesn't change anything we talked about, just the numbering. You're pleading guilty to count 3. All the other counts naming you will be dismissed. I'll sentence you as a first offender. I think you qualify for that. I think you understand the risk of it. It's a pretty limited risk because you're not going to be on probation for very long. And the only way it's a bad idea is if you get in trouble again. And I don't get the sense you're going to do that. No, she says. Okay.
No.
I'm going to sentence you a little bit differently because I want to reflect the time you served. To count 3, I am sentencing you to 2 years to serve 1 year with a balance on probation. You'll get credit for all the time you served. You're not going back into custody, but you will be on probation for a year. Special condition of probation number 1 is that you meet with a mental health provider to have an evaluation. And if that person recommends any treatment, that treatment is part of your probation. Number 2, while you are on probation, you will not work in any type of detention facility in any capacity, whether it's healthcare or otherwise. 3, no contact with either of your co-defendants. I will waive your probation supervision fees for the first 3 months as you continue to establish yourself doing what you're doing and not being in custody. And I'll be very open. It's only a year, but if probation comes to me early on saying, why are we supervising this woman? She's doing fine. If they advocate for an early termination or turning it into unsupervised probation early on, I'm fine with that. But like I said, it's a pretty small window of supervision. I'm very sorry for your loss of your daughter. And I hope that you are able to step forward and be there for your granddaughter. And if not you, then your family down in Florida. Ms. Cabrera, anything else on behalf of Ms. Callaway?
Nothing further.
Ms. Callaway, what county do you live in?
DeKalb. I live in Decatur.
Okay, I'm asking because Ms. Simpson's going to need to talk to you in a minute about reporting to probation, and it'll be in Conyers rather than here in Atlanta. Ms. Boykin, anything else on behalf of the state?
No.
Okay, thank you, everyone.
Thank you.
Thank you. Thank you, Judge.
You're welcome. Happy birthday to your mom.
I know.
Where are you taking her?
So we're gonna go to 5 Church in
Oh,
Newtown.
yeah.
Yeah.
You gonna bring the leftovers back here?
You know, you guys might still be here.
Yeah. It's been that kind of day.
Yeah, that's.
All right, friends, let's go to El Paso, Texas. We'll check in on speak, Dan. We will check in on the jail magistrate. There we go. Always a good time for this. Let's see what's going on.
So Ms. Freeman is here on 2 charges. He's got 2 misdemeanor charges. He's got a charge of burglary of a vehicle with a $2,500 bond, and then he's got a criminal trespass with a $1,500 bond, okay? Permanent attorney is a public defender's office this morning. Mr. Hernandez from that office is going to try to convince me to lower your bonds. Then I'm going to hear from the prosecutor, then I will make my decision. Go ahead.
Yes, Your Honor. Good morning, Your Honor. Good morning, counsel. On behalf of Jessica Freeman, Your Honor, she is a United States citizen. She resides here in El Paso County, Texas. Her sister is here as well in El Paso. She does have 1622 diagnoses, bipolar 1 with psychotic features, PTSD, and schizophrenia. We would request a 17.032 release with re-entry to the rescue mission for the time being. And Ms. Freeman, if the court releases you, I need you to go there. And then if you're going to move, let me know ahead of time so that we can arrange it. Okay?
Yes, sir.
Your Honor, in light of fact, these are both misdemeanors. We also were requesting a Takumi referral to keep her on medication this time, Your Honor.
Mr. Delgado, any good causes to why I should not grant a 17032 release? Like for prior criminal history or things like that?
I mean, she does not appear to have she does have some assault charges, plenty of drug stuff. I guess, Your Honor, if she can get treatment, we would really have to be.
Yeah, she's got theft, prohibited weapon, knuckles, prostitution, criminal mischief, assault, and then right now he's currently out on surety bonds on 2 cases. So you know what that's going to trigger, Mr. Hernandez? That's going to trigger a bond surrender. Okay. All right. This basically happened at let's see.
It was a motel on Alameda, Your Honor.
Yeah, motel on Alameda. Apparently, they were wandering there, but she comes there, and then she enters into a vehicle and takes $40 from the person that was staying in there or working there. Okay. Okay.
Your Honor, we would ask for special language in the release order that she be transported to the rescue mission tomorrow between 8 and 5.
All right, so these are going to be intensive level supervision PR bonds with the following conditions. 1, defendant will report to the PR officer as instructed. That means when they tell you to report, not when you feel like reporting, not, oh, I have to do something else. I'm not going to report, because if you don't, I will revoke your bond. Also, Ms. Rivera, I want her reporting in person. 2, you cannot be rearrested for any new offenses while this case is pending. 3 and 4, you're not allowed to possess or consume illegal drugs or alcohol, and when you report, they're going to be testing you to make sure you're not using. What's the address of occurrence, Mr. Delgado?
It is 4015 Alameda.
You cannot go back to that hotel. You understand that?
Yes, sir.
Go back there, come back. You said you're staying in here because if you get arrested again for anything and you're out of bond, that's going to be good cause for me not to release you under 17032. So you come back on anything, don't even ask because you're not going to get out.
Okay. Yes, sir.
And also commit no new offenses while this case is pending. Thank you.
Thank you.
Thank you, Your Honor. My excuse?
Yes, sir.
Ms. Freeman, call us when you get to the rescue mission, okay?
Well, a couple more things. Be released under reentry tomorrow morning, and then when she reports to her PR1 officer, they're going to set her up to do a Takumi screening to see if you need any mental health help. Thank you.
Thank you, Your
Do
Honor.
I need to have a cell phone number for the Takumi?
They'll give it to you when you talk to your
They'll
PR1
provide it.
officer, okay?
Oh, they'll provide, do I call my lawyer for that?
I am your lawyer.
Or do I call you, Mr. Hernandez, to know
Yeah.
when the Takumi appointment is?
Yeah, they're going to give you the information, but when you get to the rescue mission, you call me anyway, okay?
Okay. So how do I get to the rescue mission? Do I go on my own or?
They're going to deliver you
You're gonna get a
tomorrow.
free ride tomorrow.
Oh, they're gonna take me from the county jail over
Yeah,
there?
they're going to give you a free ride tomorrow morning after 8 o'clock in the morning. Thank you.
Okay, thank you.
My excuse, Your Honor?
Yes, sir.
Thank you, Your Honor.
All right, let's get okay, what's your name, sir?
Okay, give Mr. Green next, Your Honor.
Just bring her uncle, do this male and then bring the next, well, we bring the next female, okay?
I'm sorry?
I'm gonna do this male and then bring the other female and just have her sitting in there, okay?
Okay.
All right, what's your name, sir? Officer, unmute him, please.
It's unmuted, Your Honor.
All right, what's your name, sir?
Javier Hidalgo?
Hidalgo.
Yes, sir.
Yes.
All right, let's see what we got here. So Mr. Hidalgo's here on 2 charges. He's got a charge of assault against a family member with a $5,000 bond, and then he also has a charge of an injury to an elderly, I think it's an injury to an elderly individual with a $20,000 bond. Permanent attorney is a public defender's office. This morning, Ms. Quevedo from that office is going to represent you. She's going to try to convince me to give you lower bonds. Then I'm going to hear from the prosecutor, then I will make my decision as to what happens to your bonds. Go ahead, Ms. Quevedo.
Thank you, Judge. Your Honor, Mr. Hidalgo indicated he lives at 7631 North Loop, apartment 2246 with his brother. He's lived his entire life in El Paso. He is a U.S. citizen. He went to Bowie High School and then El Paso Community College in UTEP. He has his parents as well as his siblings here in El Paso. He received Social Security income, Judge, and the nature of his disability is physical and his mental health. He does receive mental health services. He has phone number 915-472-0. Says he has no access to his money. So he is asking for a bond reduction or any relief the court might find fitting. Thank you, Judge.
I misspoke at the beginning. He only has 1 charge, the injury to an elderly, okay? Mr. Delgado, prior criminal history?
Your Honor, he has a criminal mischief B, assault, family violence, impeding, and an obstruction retaliation.
All right, and what are the facts of this case?
The victim, Your Honor, it's the defendant's father. The victim is 81 years old. They were at their home, at the victim's home, 3109 Rivera at about 10 o'clock. The defendant got angry because the victim no longer wanted the defendant at the home. The defendant became enraged. He grabbed the victim by the arms. The victim said the defendant then let him go and he sat down. The victim said that the defendant sat across from the victim. The defendant began to yell at the victim. He went up to him. He began winding up his right hand and slapped the victim on the left cheek about 10 times. The defendant then started punching the victim on the chest. The victim said he was trying to push the defendant off, and the defendant grabbed the victim by the shirt. The defendant started hitting and pushing the victim's nose and the right side of his face. The victim said that once the defendant got off him, the victim was able to get the defendant to leave the home. Once the defendant was outside, the victim closed and locked the door. The victim felt pain from all the strikes. The officers noted the victim had multiple injuries, and the victim sustained a cut next to his nose, a cut on his right cheek, swollen right side of his lip was swollen and cut, and the victim's lower left cheek was swollen and red. The victim removed his shirt, and the officer noticed redness all across the victim's chest and redness on the victim's right arm. And he said he was in a lot of pain in his right hip from trying to get the defendant off of him.
All right, on this one, request for bond is going to be denied. Nature circumstances at the office, prior criminal history. Thank you.
Okay, Your Honor.
All right, I think I'm going to go back to the females right now.
Yes, you are, and then I'll switch floor to a.
All righty. All right, officer, thank you. All right, ma'am, what's your name? Ma'am, what's your name?
Danielle Green.
Green, okay. Oh, yes, okay, let's get over here, change screens over here. Yes. Yeah, Ms. Green is here on a charge of possession of controlled substance, if I recall correctly. Yeah, possession of controlled substance, penalty group 1, 1 to 4 grams, $2,500 bond. Permanent attorney is Joe Montes, but for purposes of this bond reduction hearing, you will be represented by Ms. Quevedo from the Public Defender's Office. She's going to try to convince me to lower your bond. Then I'm going to hear from the prosecutor, Mr. Delgado, and I will make my decision as to what happens to your bond. Go ahead, Ms. Quevedo.
Thank you, Judge. Ms. Green, if you're released from jail, where would you live?
I will go back to my mom's, 9912 Ballistic.
Okay, and how long have you lived in El Paso?
Over 30 years.
Are you a U.S. citizen?
Yes, ma'am.
What is the highest grade of school that you finished?
College.
Where
I have
did you
associates.
Okay, what is your associate's in?
Applied science.
And do you have any money that you can pay towards your bail amount?
No, ma'am.
Are you working currently?
No, I have a job lined up.
And what family do you have here in El Paso?
Excuse me?
What family do you have here in El Paso?
Just my mom.
Okay, do you have a phone number where you can be reached if you are released?
Yes.
What's that phone number? Do you feel like you need any mental health or substance abuse services?
I know all my resources. I know where I can go.
All right, thank you.
Need to
Ms.
go.
Your Honor, based on the information provided, we're respectfully requesting PR bonds or any relief the court might find fitting. Thank you, Judge.
Mr. Delgado, prayers?
Your Honor, she has a criminal trespass, a theft B she got deferred on, 3 deliveries of marijuana, state jail that she got deferred, and a possession of penalty group 2, 1 under 1.
Yeah, it's under. All right, so this one basically, long and the short is that they found her with 1.1 grams of fentanyl. Okay, pretty bad stuff, if in fact isn't true. So it's gonna be a PR bond under enhanced level supervision with the following conditions. So you listen very carefully, because I'm not playing any games with you in here, okay? You must follow each and every one of these conditions, because if you don't, we'll revoke your bond, bring you back to jail, and you can sit it out here until your case goes to trial, until you dispose of your case. Condition number 1 is you will report to your PR bond officer as instructed. That means you will report on the day they tell you to report, not when you feel like reporting. 2, you cannot be rearrested for any new offenses while this case is pending. 3 and 4, you're not allowed to possess or consume illegal drugs or alcohol, and when you report, they're going to be testing you to make sure you're not using. Understood?
Understood.
Thank you. Let the officer know that you're done.
Okay, thank you.
Okay, I'm gonna get the last Rivera.
All righty. This is gonna be Britney Rivera. All righty. So this is Britney Rivera. She's here on a charge of driving while intoxicated with an alcohol concentration greater than 0.15. The bond is set at 20,000 with DWI conditions. Her permanent attorney is going to be, let me check that out real quickly. Jeff Frago, but for purposes of this bond reduction hearing, you will be represented by Ms. Quevedo from the Appellate Defender's Office. She's going to try to convince me to lower your bond. Then I'm going to hear from the prosecutor. Then I'll make my decision as to what happens to your bond. Go ahead.
Thank you, Judge. Your Honor, Mr. Rivera lives with her mother at 14830 Shade Drive. She's lived most of her life in El Paso. She is a U.S. citizen. She went to Triumph Academy where she completed up to the 11th grade. She has her mother, her siblings, nieces, and nephews in El Paso. She works for Summit Plastic Molding. She gets mental health services from EHN. She has about $200 that she can post, and she can be reached at 915-412. Asking for bond reduction or, of course, a full PR bond, whatever relief, if any, the court should find fitting. Thank you, Judge.
Mr. Delgado, prior criminal history. I know he's got at least one prior DWI.
Correct. And then in evading with the vehicle, she got deferred on.
All righty. This one, basically, she's asleep at the wheel, intoxicated, signs of intoxication. She ends up blowing 0.164, pretty much double the legal limit, okay? What I've noticed about his last DWI, she just barely, like in November, got probation revoked. I'm gonna put this one at 3,000 with conditions. It goes down from 20 to 3, but with the conditions you were explained in magistration. On any car you are driving, you will install camera, ignition, interlock device, in which you're gonna be blowing every time you're driving to make sure you're not drinking. If you're not driving any cars, you must obtain a portable unit in which you're gonna be testing several times a day. You must report to a supervision officer as instructed. That means you will report when they tell you to report, not when you feel like reporting. You cannot commit any offenses while this case is pending, and you're not allowed to possess or consume illegal drugs or alcohol. And when you report, okay?
Okay,
Thank you.
thank you. I'm sorry, Judge.
All right, friends, let's head back to Georgia. New contestant in front of Judge McBurney.
Okay. All right. While you're getting set up, Ms. Smith, I'm going to get us teed up. This will be our last thing before we break for lunch. This is 25 SC 007473, State versus Miles Harper. Mr. Harper, thank you for your patience this morning. He is represented by Ms. Sherry Lassiter, who is also here. Thank you for your patience. Ms. Smith is representing the state, and in a moment, when Ms. Smith is all fired up, she's going to swear you in, ask you some questions you've heard other people be asked today. I may have a few questions. I'll hear from your lawyer and from you, Mr. Harper. If there's anything you want to add, we'll get you sentenced and out the door. Okay? All right. Ms. Smith?
Yes, Your Honor, thank you. Mr. Harper, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Miles David Harper?
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you would normally take that you haven't been given today?
No.
Are you able to read, write, and understand the English language?
Yes.
How old are you and how far have you gone in school?
I am 33 and I have a bachelor's degree from Morehouse College in math.
In math, you said?
Yeah.
Ooh, all right. What do you do with that?
Data analytics and a manager of a data analytics team as well. So kind of do two jobs at once.
All right.
Ms. Smith, pull your microphone down, please. Thank you.
Sorry about that. Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes.
Do you need more time to discuss your case with your attorney?
No.
And are you satisfied with her services?
Yes.
Counsel, are you satisfied that your client has a full understanding of this proceeding? Yes. Also, do you waive the formal reading of the indictment and any and all defense in the indictment for the purposes of this plea? Waive. Mr. Harper, do you remember being arrested on these charges?
I do.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 6 years probation?
Mhm.
Yes.
You got to say yes or no.
Yes, sorry.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today?
Yes.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm? And that if you did, you could be charged with another felony offense.
Yes.
It's my understanding that you want to take this plea under first offender. Is that correct?
Yes.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pleaded guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No.
Has your lawyer explained the First Offender Act to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment?
Yes.
Do you understand that the federal government considers a first offender plea a conviction for purposes of deportation and can still affect your ability to remain,
Yes.
if that was an issue? Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea? Yes. Mr. Harper, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No.
As to indictment number 25 SC 007473, how do you plead to count 1, criminal damage to property in the first degree, and count 2, criminal damage to property in the first degree?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to appeal directly from your guilty plea, but if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal?
Yes.
Do you understand that that process must be completed within 30 days from today?
Yes.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
Thank you, Mr. Harper. Your Honor, in this case, we're to proceed to trial. The state would show that on September 7th, 2024, officers of the Atlanta Police Department responded to 390 17th Street, Northeast Atlanta, Georgia, also in Fulton County. They responded to a shots fired call. When they got to this location, it was an apartment complex, but they went to a parking garage in the Atlantic Station community, and the officers were told that there were just people on the parking deck that were shooting. When the officers investigated, they were able to see several shell casings by 2 of the cars that had been hit by bullets. They had damage because of those bullets also. One of the officers with the Atlanta Police Department went to the leasing office a few days later and watched a video that depicted the defendant and another unnamed person shooting at a third person that was riding on a bike. Now, is the state's belief or version of events is that the defendant and his friend went to this apartment complex and they both ride motorcycles. They got off of those motorcycles, and the defendant's friend or the person he came with, a third person came to steal his bike. So his bike was being stolen. As that person was driving away with the stolen bike, the defendant and a second unknown person started to shoot at the person who was stealing the bike. When they started to shoot at the person that was stealing the bike, 2 cars were hit in the midst of it. APD, through their investigation, were not able to identify who that person was that was shot at or potentially shot, hence why there's no charges for aggravated assault here. However, with the 2 charges we do have here, those are the facts. Those 2 cars were shot, and I was able to speak with the victims of both of the cars here, and they've sent me estimates and receipts of them getting their cars fixed. One car's windshield was broken. Another car had a shot going through their hood where their radiator was broken, so they had to get that completed. I've I've been able to get those documents. I'll share them with counsel, and we are asking for restitution in this case. But those are the facts of the case. Regarding the charges that we have before us, the negotiated plea is for count 1, sentencing to be 3 years probation, and then for count 2 to also be 3 years probation for those to run consecutive. Regarding the special conditions of probation, the state is recommending for the defendant to complete 50 hours of community service and anger management course, for him to stay away from the incident location, and for him to pay restitution to the victims in this case. Again, like I stated earlier, there was video footage of this. I've seen it, the defense counsel has watched it also, but because of that, this is the negotiated plea that we're presenting to the court, and that's all from the state, Your Honor.
So the cars were sort of innocent bystanders.
Yes.
Unfortunately, it was cars and not people, but Mr. Harper and someone else decided it was worth risking life, limb, et cetera, to shoot at someone who was stealing a motorcycle.
That's correct.
Okay. And we don't know if the guy on the motorcycle got hit. He didn't stop. He sped away on the motorcycle.
Well, he fell off.
Oh, he fell off.
He fell off the motorcycle and then ran away. I'm not sure if that person was shot or not.
Okay. Regardless, he left. He didn't stick around to say, wait, why are you shooting at me? Or I'm so sorry, or whatever. Okay. Interesting. Any reason why Mr. Harper is charged all by himself and not the other guy who was shooting?
Well, the police officers were able to identify Mr. Harper through his license plates that was on his bike.
Okay.
And he fit the description of the person in the video when they were able to identify him.
Got it.
I just think unfortunately the second person was not identified, and we didn't have any information on him.
Okay. Got it. Ms. Stallworth, criminal history information on Mr. Harper.
There's no prior history.
You've been boring the last 2 of these. Okay, appreciate it. We will see you at 1:30, please.
Okay, see you then.
Thank you. Have a good lunch break. Ms. Sherry Lassiter.
Okay, yes, Your Honor. Before I get into explaining who my client is as a person, I want to speak on the facts just a little.
Sure.
The situation was, no good deed goes unpunished. He gets a phone call and said, hey, somebody's stealing my bike. I don't know what's going on. I need help. So he comes to the location, which is the parking garage. As he's walking up, he sees a person on the bike. He's walking up the ramp to the parking garage. He hears gunshots and sees gunfire. He doesn't know what's going on, so he ducks behind a vehicle. You can see him on the video, ducking behind another vehicle. He's shooting because he's thinking he's being shot at. So there's this other unidentified person coming from another direction shooting as well. I think we were still waiting on ballistics to find out exactly what shell casings and what gun it belonged to, but my client at this point is willing to take responsibility, not knowing if it was from the other person's gun or his weapon. And then the person, I believe, it seems like he dropped the bike and jumped off. It didn't seem like he was hit on the video. It seems like he just was like, oh, it's too much going on. I'm getting out of here.
Right, not worth
Forget
it.
this bike. Yeah, forget stealing this bike, stealing this motor vehicle. And he runs off. And my client Mr. Harper doesn't have any criminal history. He's 33 years old, a mathematics graduate of Morehouse College in 2015. This is not his life. And I appreciate the state being willing to look at those factors as well. He is employed. He has 2 jobs, Comcast and a tech company called PDI, where he does data analytics. He's involved in his community. He helps the elderly in his neighborhood with, yard work or things like that people need assistance with. And again, like I said, he has a bachelor's degree in mathematics. We do ask the court accept this plea under first offender. The restitution, I'm still kind of murky on, so I'm not sure the exact amount.
Well, the way we're going to handle that, just so there aren't any questions, the victims to the counts to which Mr. Harper is entering pleas are entitled to restitution if it can be proven up. And so Ms. Smith has previewed the fact that it looks like she's getting some paperwork. She obviously has to get that to you. If you contest it, we have a hearing, and if they prove it up, then those are the dollar amounts. It may be that you and Mr. Harper look at it and say, hey, how about, I'm making numbers up, how about we just agree $1,000 for this guy, $500 for that guy? There also needs to be evidence that they didn't get insurance coverage for it because they can't double recover.
Right.
And it may be they decided not to use their insurance because they didn't want to hurt their policy or who knows what. But those are all fair questions for you to ask of Ms. Smith. as she gets you that info. If there's a meeting of the minds, then Ms. Smith will just send an email to Ms. Nelson, copying you, saying, could we please amend the final disposition to add X dollars of restitution for this guy and Y dollars for that guy? If there's not a meeting of the minds, then we have a hearing. It's a little evidentiary hearing that is either based on the documents, or it may be that the two gentlemen whose cars got shot up, that they come in and they say, here's, yep, I got it fixed. I didn't use insurance. And we can make a big mountain out of it. It can be a small mountain. It also depends on the dollar amount. You know, if it's $100,000, I would expect a whole lot more pushback than, hey, you know what? It cost me $50 to replace the hubcap on the car. You know what? I'll give you $50. I want to move this behind me. So real reason, but you need to see the paperwork first. It's not simply that the state says, the victim says it was $400. Okay?
Okay, thank you.
You bet.
And then I believe we agreed to a behavior incentive date of 3 years.
I didn't hear that. Did,
A part of the plea is if he was taking the plea on the first offender, the state would ask for a 3-year bail date.
Okay.
It's entitled to.
And in addition to that, I'm just going to push it just a little bit more and see if we can have it based on his cooperation and having no further issues, if he can go to non-reporting after 1 year.
okay, we'll see.
Okay. And to have this filed under seal.
All right. Anything else?
The community service that we talked about was 30 hours. I believe the state mentioned 50. I just want to make sure we're clear on the number of community service hours.
I have 50 on my paper, but let me go back to our conversation.
I have 30 in the email. I just want to double check.
I'm gonna go with 50, so.
Oh, you gonna go?
Yeah.
Okay, all right, Your Honor. I just had to put that out there. And that's all I have. We just ask that you accept this negotiated plea.
Okay. Mr. Harper, anything you want to add?
I've learned a lot from this. Learned I'm not built for jail. Sitting in the cell.
You were only there 3 days. That was 3 too many?
3 too many.
Okay,
So,
I hear you.
ever since then, been trying to stay on the straight and narrow.
Well, you were on the straight and narrow. I mean, to your client's point, it's not like, because I get cases where this is the 9th time someone has shot up a car. And like, this isn't just about, I'm trying to help a friend and there was a crime going on. Don't play Rambo cop anymore, though. If something's going on, say, hey, that's too bad, man. I hope you get your bike back. I'm staying in my apartment.
Yeah, the plan is, I mean, I've already gotten rid of my firearm, just sold it, got rid of it, didn't need it anymore.
Great.
Just want to avoid
Good.
anything.
You are moving in a great way. 2 jobs. You're in a management role already. You've got a great degree from a phenomenal institution. Keep going in that direction. If you want to do a family, do a family. All those things are great. And they only get held back when you're like, hey, you know, I'm going to go help my friend, so I'll just put my piece here and we'll do this. And that can end so. And you're firing these rounds and there's a kid walking through the parking deck and you didn't know it and you didn't mean to hit him, but that death is on you. And we're not talking about probation or this or that. It would be, well, would that be voluntary manslaughter, murder, and that's never in your heart. That wasn't in your heart at all, but that's what can flow from something like that. But you learned it. I'm preaching to the choir here. Any other questions?
The only thing is I do planned on doing a little bit of traveling in the country, not out of the country, but I didn't know how that would impact that. I know the probation, you have to speak to the probation officer, but I wasn't sure if it was just no travel for X amount of time and then it ramps up or anything.
No, it's seek permission first.
Okay.
And so you probably wouldn't want to do it week 1 because they wouldn't have gotten a good read of you. You seem like you're going to be a very low maintenance supervisee, but there's no guarantee. And so you would want to have a few months of good rapport with your officer under your belt before you say, hey, I'm going to Colorado with some friends. Show me the itinerary. Great. When are you going to be back? And they either get permission from me or they may be authorized to give you that permission for leisure travel. Where it's a problem is if you say, oh, my new job and I got to be in Chicago all the time. They can't supervise you if you're in Chicago all the time. But a one-off trip here and a one-off trip there generally is not an issue. Just the key thing to remember is you get approval before you go.
Understand.
And if you're not getting approval, you let Ms. Sherry Lassiter know. She reaches out to me and I can engage with probation saying, tell me the concern. And then I can let you know, hey, that's a valid concern. You keep testing positive for this when you take it. I'm making it up, but whatever the deal is. And if it doesn't seem reasonable to me, I'll say, fine, I'll authorize it. Let the guy go to Chicago. He wants to see a Cubs game or whatever it is you travel for, a math conference. So anything else?
No.
Okay. Well, Mr. Harper, I find there's a factual basis for your plea. It sounds like you processed this, and I appreciate it was a long time ago. You've had a while to process it. I'm glad no one got hurt. At least we don't think the guy on the bike got hurt, but that was on him. I also find that your plea is knowing and voluntary, meaning you've understood what we've talked about. No one's forcing you to enter this plea. You agree with that?
I agree.
All right. Ms. Sherry Lassiter, can someone in my office sign the indictment for you?
Yes, Your Honor.
Ms. Smith?
Yes, Judge.
And Mr. Harper, can we electronically sign your name to the indictment indicating your first offender plea to both counts?
Yes, Your Honor.
We'll do that. I will sentence you as a first offender. I think you understand. I know you appreciate the benefits. It's not a conviction. When you leave here today, you're not a convicted felon. As long as you finish out probation with no major hiccups, you remain not a felon. I'm happy to seal things. You should submit a proposed order. Copy Ms. Smith on the email that you send to Ms. Nelson, and that proposed order should be in Word format. The downside to first offender, I need to say it on the record, just so you know, but I know your lawyers told you, is that you're on probation for a while. And even if I give you the behavioral incentive date, it's a few years. If you have a hiccup in a big way and you get arrested 6 months from now because you fired your gun in a way you shouldn't, it's all going to come tumbling down. I can take away your first offender status and resentence you up to the maximum on both counts. I don't see that happening, but I need to make sure you understand that that's a possible consequence if you have trouble staying in the right lane while you're on probation.
I understand.
Okay, do you want to be sentenced as a first offender?
Yes, please.
I will do that. I will follow the negotiated resolution to this extent. 3 years probation on count 1, 3 years probation on count 2. I'll stack them, meaning a total of 6 years probation. That's a little longer sentence than we normally see for someone with no history, but it fits the, I shot my gun, and did they kick you out of the jury room?
Yes.
I tried to see if we could move, we have a meeting.
Yeah, it was fine.
I'm sorry. You can be in here. I tried to get it moved to a different jury room, but I had to do that. Anyway, because of the nature of what was involved, and it could have been so much worse, I think 6 is a reasonable window, but I will set a behavioral incentive date of April 22 of 2029. That's 3 years from today. If you have done everything you needed to do, and there are actually not many steps you have to take, then probation can, that's actually closing the case out. Well, before then, I suspect you will be unsupervised. I don't need to recommend that. You earn it by being low maintenance. And because it's a property crime rather than you stab someone, the probation is likely to turn it into unsupervised pretty early on, provided you're doing all the things you need to. Special condition of probation number 1. So there was a request for a stay away, but I couldn't tell if you lived there. I'm not going to make you stay away from your own parking deck.
No, I wouldn't have any reason to go over there.
Great, then don't.
That's easy.
Stay away from that parking deck. And you'll need to complete 50 hours of community service. You'll need to knock that out in the first 6 months of probation. So you'll just be done with it. Take care of that. Obviously no firearms while you're on probation.
Understand.
You're not a convicted felon, but first offender probationers, that's what you are, may not have firearms. It's actually a felony offense to have a firearm as a first offender probationer. You told me you already got rid of it. You sold it. Once you're done with your sentence, you're not under that sentence anymore, should you choose to. It is legal. It is allowable for you to get back into the I own a firearm business if that's what you want to do.
Understand.
No restitution at this point, but just you're on notice. We may come back and have a conversation about restitution. The state's gathering that paperwork. It may be that we don't have to have the conversation because your lawyer looks at the paperwork and says, Mr. Harper, this is all legit. It's a windshield, it's a radiator, and these don't look like crazy prices. And then you'll agree, that's my restitution. But you don't have to agree to it. The state has to prove it up. And so if we need to have a hearing, I'll happily do that.
Understood.
What county do you live in?
Cobb County.
Cobb County. All right. When we're done with this conversation, Ms. Simpson, who is with felony probation, is going to give you reporting instructions. Where is it in Cobb? What city?
It's in Marietta.
Marietta. So the Department of Community Supervision's office is in Marietta. You'll need to report there. Ms. Simpson's going to let you know where that is and when you need to be there. But that's a hot date. It's not a, hey, it'd be good if you showed up around that time. If you don't make it, they try a couple times to track you down. And if that doesn't work, they send me a warrant. That is a really bad start to first offender.
Yeah.
So don't miss your hot date, okay?
I won't.
Good. Ms. Sherry Lassiter, anything else on behalf of Mr. Harper?
That covers it. Thank you for your attention to this matter. I appreciate you hearing us out.
No problem. Ms. Smith, anything else on behalf of the state? All right, Mr. Harper, good luck with everything. Please meet with Ms. Simpson before you go, and then you are all done.
Thank you.
Okay, all right. We'll go off the record. Ms. Rivers, we'll see you at or we'll have you back at 1:30, please.
Wrapping up episode number 274 today of TCF Live. I can't believe we've done this many morning shows already. It's amazing to me. But we got a few more minutes left. Let's finish out our day back in El Paso.
And I'll make my decision. Go ahead.
Thank you, Judge. Mr. Armendariz, if you're released from jail, where would you live?
I'm sorry?
If you're released from jail, where would you live?
1714 Carweiler. It's my mom.
How long have you lived in El Paso?
24 years.
Are you a U.S. citizen?
Yes.
Okay. And what is the highest grade of school that you finished?
High school.
What high school did you graduate from?
Irvin High School.
Did you do any college or trade school after that?
No.
Do you work, Mr. Armendariz?
No.
Besides your mother, do you have any other family in El Paso?
My pops.
Okay. Do you have any money that you can pay towards your bail amounts?
Me personally, no.
Do you have a phone number where you can be reached if you are released?
915.
All right. Thank you, Mr. Armendariz. Your Honor, based on the information provided, we're respectfully requesting PR bonds or any relief the court might find fitting. Thank you, Judge.
On the assault case, I cannot give a full PR bond, even if I wanted to. The Texas
Sorry,
law.
Judge, yes. Bond reduction
All right.
on the assault and a PR bond or any relief the court might find fitting on the other case that qualifies.
Mr. Delgado, prior criminal history?
Your Honor, he's got juvenile history, but no history as an adult.
All right, so basically, go briefly over the facts on both cases, please.
Yes, Your Honor. So basically, just a kind of a quick summary,
Yeah.
chokes the victim, then takes her car. But what happens is this begins at an argument that happened because the victim left Union Draft House early. The defendant got angry, so they went home. When they got home, they continued to argue. The defendant got physically aggressive. He grabbed the victim with his right hand by the neck and proceeded to slam her to the ground. The defendant then grabbed her by the neck. It was approximately 2 seconds. It caused pain and she couldn't breathe. She said the defendant then continued to yell at her as she was laying on the ground. She tried to defend herself by pushing him away. She said the defendant then proceeded to grab her by the neck and slam her on the ground again. Then she got really scared. She tried to run to the bedroom and lock herself in. She was hiding in the closet with her dog. The defendant forced his way in, breaking the bedroom door, made entry into the closet where she was hiding, and he continued to insult her, to verbally assault her. At that time, she called the police and her friends. Officers noted the victim's neck had redness and marks. The defendant, as one of the friends showed up, the defendant tried to leave. He grabbed the victim's cell phone and car keys. The friend was able to get the phone back, but the defendant left in the victim's vehicle. When the officers got there, the victim was on the phone, actively trying to ask the defendant to bring her vehicle back. He refused and would not return her vehicle.
Okay. The UUMB, that's going to be a full PR bond. The assault's going to cut it in half, 7,500, but with conditions. So listen very carefully, sir, because I am not playing any games with you in here. You must follow each and every one of these conditions. Because if you manage to post this bond and if you don't follow them, we'll revoke your bond, bring you back to jail on a much higher bond. Condition number one is you will report to a PR bond officer as instructed. That means you will report when they tell you to report, not when you feel like reporting. 2, you cannot be rearrested for any new offenses while this case is pending. 3 and 4, you're not allowed to have any contact of any kind whatsoever. Name of the complainant and the address, Mr. Delgado?
Clarissa Robles. Her address is 3828 Tierra Alamo.
You cannot have any contact with her with any kind, and you cannot go within 200 yards of her house. Please understand this, that no contact orders between you and the court. She has no say on that matter, okay? If you go back over there and we find out, we're gonna revoke your bond, okay? She cannot give you permission to violate this order. The only way this order gets changed or modified is if you come back to court with your attorney. We have a modification hearing, and then the court determines whether that's the proper thing to do. Thank you.
Let's see over there, Zachary. Sure.
Judge,
Yes,
what's the provision level?
intensive.
Thank you.
Mhm. What's your name, sir?
Zachary Dennis, sir. Dennis, Dennis.
Let me get you under Zachary in here anyway. Yeah. So Mr. either Dennis or Mr. Zachary Howard, whenever you go to, he's here on 3 charges, 3 misdemeanor charges. He's got 2 charges of making a terroristic threat, and then he also has a misdemeanor charge of criminal mischief over 100 less than 750. Your permanent attorney is the public defender's office. This morning, Ms. Quevedo from that office is going to represent you. She's going to try to convince me to lower your bonds. Then I'm going to hear from the prosecutor, Mr. Delgado. Then I will make my decision. Go ahead.
Thank you, Judge. Mr. Zachary, if you're released from jail, where would you live? What's your address?
The address is 1208 Myrtle Avenue.
Okay, and how long have you lived in El Paso?
I live in El Paso for about this is the 8th day that I've lived in El Paso.
Okay, where were you living previously?
I plan on staying here for a good.
Where were you living previously?
I'm sorry.
Where were you living before living in El Paso?
I was living in Las Cruces.
Okay, and how long have you lived in Las Cruces?
About 38 months is how long I lived in Las Cruces for.
Okay. Do you work?
Actually, I work. I don't work right now, but I have applied for a job in El Paso already. About 6 days ago, I applied at the McDonald's, and he said he would get, and I guess he just got a hold of him. I don't know. It's funny because I've been all around El Paso, like the whole city of El Paso, and I don't know. I mean, this is kind of where I'm stuck at, like as far as what. This is kind of where it all ended at, was here at the court with you guys, so I don't know.
Okay. Do you have any money that you can pay towards your bail amounts?
Not right now, I don't, ma'am, no.
Do you have a phone number where you can be reached if you are released?
I don't.
All right. Judge, do you need a safety plan or?
It would help. It would help. I mean, the allegations are pretty serious, okay? But yeah, if you guys want to go for a safety plan, go for it, because right now I'm not too comfortable.
Is there a 1622?
You know what? I don't remember. I'll put a notation to request one, okay?
Okay, so then yes, Judge, we'll just reset it for a safety plan.
All right, thank you. Yeah, we'll do that. You guys set it whenever you're ready, okay? Thank you.
Okay, thank you.
Thank you, sir.
Thank you.
You're gonna get some today, sir. How is he doing?
Okay, friends, that's about going to do it then for today. I hope you all had fun. I know I did. We'll be on here tonight for Sidebar, 8 p.m. Eastern, 5 p.m. Pacific. I don't have that scheduled yet on the channel, but that'll go up in the next hour or two. So do check out that. And we'll, of course, be back tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour early if you're a channel member. So join us for that as well. Go have yourselves a great day. I hope you had fun. I appreciate you spending your time with me. Take care. God bless.